open the meeting, and please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we have a full board and of commissioners plus the county administrator. Adoption of current agenda.
Mr. Chairman, I move that we adopt the current agenda as presented.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Aye. Approval of warrant registers and payroll rosters.
Mr. Chairman, today we have three. The first is fund expenditures. I move to approve fund expenditures in the amount of $335,710.64, and note that it has been reviewed by two representatives of the Auditor's Office and the County Administrator.
Second.
I have a motion and a second. All in favor, say aye.
Aye.
Aye. The motion passes.
And next, we have another fund expenditure in the amount of, I move for the approval of the fund expenditure in the amount of $109,812.47. And again, note that it has been reviewed by two representatives of the Auditor's Office and the County Administrator.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Aye. The motion passes.
Mr. Chairman, next we have, I gotta finish signing that one. Next, we have the payroll clearing and emergency management payroll. I move to approve the amount of $1,240,061.92, and note that it has been reviewed by two members of the Auditor's Office.
Second.
I have a motion and a second. All in favor, say aye.
Aye.
Aye. Motion passes. Moving on to consent agenda.
Mr. Chairman, I move that we approve the consent agenda items 1 through 7 as presented.
Second.
I have a motion to pass consent agenda items 1 through 7. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. Public comment. Is there anyone in the room for public comment today?
George Dockstutter. I want to talk a little bit about our debt. We got a mountain of debt so high a show dog can't even jump over it. And there's a few things I feel that county commissioners and the administrator can do. And that's, if it's a non-budgetary item, we don't need to spend the money. We need to tighten the belts all the way up and start trying to cut down what we've got. Number two is you guys got to get off your horse and get rid of these VEBA accounts. There's nobody out there that's an employer that's paying his employees because they don't take his insurance. This is getting ridiculous, and it needs to stop throughout the whole county. Now, some of them are under contracts, but as soon as they're over with, you need to get rid of it. And third, I've sat here and listened to the county assessor say that he needs another appraiser because he's 2 years behind on new construction appraisals. Well, it's pretty simple. All these new subdivisions out there, when the house is sold, it should just go on the tax rolls. That's what a fair market value is. You don't need an appraiser to tell you that some builder sold a house for $450. We need to go appraise it. Let's get it on the tax rolls and start collecting our fair share from them. Thank you.
Thank you. Anyone else for public comment? Is there anyone on the phone? No one on the phone? Okay, I'm going to open the open meetings with Derek Bratton, Planning Director on the Comprehensive Plan Ordinance.
Thank you, Chair. Yes, this is a open public hearing regarding the 2023 Franklin County Comprehensive Plan Amendment docket. So the way I'm going to present this is we have two applications within the docket. The board has an option. They have options. You can either vote the entire docket, and that's Ordinance A that you have in your packet, or you can, partially support the entire docket such that each CPA can also be adopted individually, if that makes sense. What I mean by that is it's not an all or nothing scenario. That's why you're provided with three ordinances. The first, A, is if you want to adopt the entire docket. The B is if you want to only adopt CPA 2022-01 and Ordinance C copy. They all have the same number because you're only going to sign one. Would be for CPA 2022-02. However, this is a public record, open hearing. The board is under no obligation at this time to take action. If the board desires more information, it can keep the record open until it is satisfied it has received enough information in order to make its decision. So with that, if there's no questions, I will proceed with the presentation.
Questions? Proceed.
So, first one is CPA 2022-01, Olberdine. It's a request to change comprehensive plan land use designation of approximately 162.3 acres of land from agricultural to rural residential. It consists of 4 parcels. Wait, 1, 2, 3, 4. Yeah, okay. Property is bounded by the city of Pasco to the west and south, which is currently active crop circles, and the Clark's Addition Lambert to the east and active crop circles to the north. The properties to the north are agricultural, AP 20, to the west and south with the city of Pasco's low density residential land use designation and with a rural residential land use designation to the east. This is the property. And this is the comprehensive plan land use designation map. So that's rural residential. This is the subject property. This is the city of Pasco, and these are AP 20 zone crop circles. There's an aerial of the site. Again, that's Clark's Addition there. This area here is the city, and then this is the county, AP 20. Technical agencies were notified on July 20th, as well as notices mailed to the property owners. It was posted in the paper, and the property was posted with sign on July 21st. And Department of Commerce was notified as part of the 60-day review process on July 25th, and the 60-day review ended on September 25th. We reviewed the checklist and issued a determination, the SEPA checklist, determination of non-significance on July 20th. Department of Ecology filed a notice under SEPA Registry 202-303-411. And comments were due by August 3rd. So, staff analysis, RCW 36.70A0705D establishes limited areas of more intense rural development. Lammert, which are designated areas where more intensive rural development can occur. Clark's Addition is a type 1 Lammert with a rural residential comprehensive plan land use. And RCW 3670A0705DC4 states that Lammerts cannot expand beyond a logical outer boundary in order to create new pattern of low-density sprawl. 4 conditions counties need to address when establishing governing LOBs: the need to preserve the character of existing natural neighborhoods and communities, physical boundaries such as bodies of water, streets and highways, and land forms and contours, prevention of abnormally irregular boundaries, the ability to provide public facilities and public services in a manner that does not permit low-density sprawl. In reviewing the LOB rules for Lammert, staff made the following determinations. The application meets 2 out of 4 conditions, B and C, due to the establishment of Clark Road as a clear line between agricultural and residential, along with removing the agricultural barrier between UGA and Clark's Addition. Case for condition A could be made either in support or opposition, depending on how one views the interaction between the UGA and Clark's Addition. Condition D.
Eric, would you please speak closer into the mic?
I'm
I can
sorry.
barely hear you.
Condition D is why staff is recommending denial of the application is due to the purpose section for rural residential zoning district governing Clark's Addition, making multiple reference to the zone being low density in nature. Basically, this would be the reason why condition D is because it's expanding that low density residential into an adjacent property. It's effectively expanding the LOBs. One of the policies of the 2018-2038 Franklin County Comprehensive Plan, which governs the rural residential areas, is to contain the size of the rural residential area without expanding the established LOB. The descriptor for rural residential further states the LOB for these areas will not expand during the life of this plan. The expansion of the LOB would counter countywide planning policies on reducing the inappropriate conversion of undeveloped land into sprawling low-density development. WAC 365-196-42561D, ID states the fundamental purpose of the LOB is to minimize and contain the Lammert. WAC 365-196-4256-IE does give counties the ability to consider changes in future amendments. However, counties have to use the same criteria originally used to designate boundaries and should avoid adding new undeveloped parcels as infill, especially if doing so would add to the capacity of the Lammert. While proposal potentially meets 3 out of 4 conditions for LOBs as laid out by RCW 3670A0705DC4, it does not meet the condition regarding the ability to provide public facilities and public services in a manner that does not permit low-density sprawl. Determination regarding whether lands are designated agricultural, that I think we're okay on now. At the time it was fluxed. This regards to the concern with regard to future-wise appeal of the 2018-2038 Comprehensive Plan. Under question in that action was whether or not certain lands within the county that were in the UGA and other designations of Franklin soils and or Franklin crops were determined to be all tax. At this time, though we have not received final compliance notification from the Eastern Washington Growth Hearings Board, the Supreme Court decided not to review the appeal, and in that appeal, Growth Hearings Board found us out of compliance, claiming that the Franklin soils was an all-tax. We appealed that. The appeals court concurred with our position that they were not all-tax and that it was a planning designation. And Future Rights appealed that to the Supreme Court. The Supreme Court refused to review it, and therefore The appeal ruling stands. However, we're still waiting for the Growth Management Hearings Board to do their final piece, which is to declare that we are in compliance, and it's a procedural matter. So, that said, that's an issue, but it's not an issue per se at this point due to the fact that it appears that those are going to be designated as non-all tax Franklin County soils. So that's there. It's still technically there because we haven't gotten the compliance ruling, but it's a formality at this point.
So we believe these lands will not be considered all tax.
That is correct. It still has an issue with the LOB. State law and comprehensive plan do not provide a process allowing the LOB to be expanded at this time. And then we are doing, and we're kicking off our periodic review this year, starting in the summer. We'll be doing some preliminary work, but our funding kicks off in the summer. And that update is due June 30th, of 2026. We received comments from Franklin County Public Works, Franklin PUD, Washington State Department of Commerce, and Franklin County Planning and Building. I thought I'd updated this, but we actually, at this point, we're up to 7 comments in opposition to the proposal. They are included both in your packet, and then some showed up after we submitted the packet on the 30th, and those have been handed to you as well this morning. Planning suggested findings of fact is the proposal is not in accord with the goals and policies of the comprehensive plan, including the countywide planning policies. The effect of the proposal on the immediate vicinity will be materially detrimental to the land use. The proposed amendment will not result in probable significant adverse impacts to the transportation network, capital facilities, utilities, parks, and environmental features. That can't be mitigated. In the case of an amendment to the comprehensive plan, land use area map, the subject parcels being designated are not physically suitable for the allowed land use. The proposed amendment is not consistent with the Growth Management Act, and the amendment does not advance the public health, safety, or welfare. In the case of an amendment to the comprehensive plan, land use map, that the subject parcels being designated are not physically suitable for the allowed land uses in the designated nation being requested, including compatibility with existing and plans surrounding land uses. Whoops. The proposed amendment is not consistent with the Growth Management Act, and the amendment does not advance the public health, safety, or welfare. Now, that is staff's position. The Planning Commission, at their October 3rd meeting, voted to recommend approval. Staff prepared and presented to the Planning Commission alternative findings of fact to support their recommendation. Those have also been included in your packet. This is not usual. We do not normally have split recommendations, but it needs to be remembered that staff is an independent body of the Planning Commission, and our interpretation of the regulations does not agree with the Planning Commission's recommendation. Therefore, you have a split recommendation.
Mr. Bratton,
Yep.
before we go on, could you, we have the information, but would you inform the public of the vote by the Planning Commission? What was it?
Yeah, I was going to,
Unanimous,
because I
correct?
realized, yes, it was. If you also read in the minutes, there was a little bit of contention with regard to the fact that we even brought it to them. So the Planning Commission made its recommendation, staff made its recommendation. The board has before it the ordinances. If the board supports the ordinance or the Planning Commission recommendation, you would sign the ordinances. If, on the other hand, you want to go with the planning staff's recommendation, you would not have to sign anything. It would just be based on the findings of fact submitted as planning recommendations. Provided to you were the recommendations for both parties, or both recommendations. Also, one of the applicants have provided additional suggested findings of fact from their perspective. And any of these are the option of the board. You can mix mash. This is not like a closed record where the board is kind of locked into what is going on at the time it's presented. This is a policy document, and the board has the discretion. However, there are regulations at the state level, and that is why staff has made its recommendation, because we see a potential conflict, not a potential, we believe that this is a conflict with state law, and that the county will, there will be ramifications if this is approved at this time. This is not to say that this option is not available for the clients or the applicants during the next update cycle, and that is the more appropriate time in staff's opinion to apply for these amendments.
Mr. Chairman, may I interact?
Yes.
So is this a proper time to ask multiple questions about this?
Yeah, is the hearing open?
Yes, it is.
Yep.
So could you take us back just a little bit and help us? Will you bring back up the map of this property, please? The next one, that one right
Yeah.
there. So would you kind of give us a brief history of why that was not, this site was not included in the UGA expansion that happened last year?
This comes from, first of all, the county does not determine what is applied for by the city. The city makes its recommendation, and I will get into your specific point. I just want to get that out there, that the county has no say over what the city requests for its UGA, except for the fact that we kind of can say no, or you need to show us why you need that.
So the decision is made by this board, correct?
The final determination, but it's based on, so the city will make its recommendation, and they will provide a calculation and analysis that shows the justification for the requested UGA expansion.
Sure. So
If
so
the
this
county, if the county.
excuse me. So
Go
this
ahead.
this was inside of the UGA. Can you describe why that it was removed from the UGA expansion request?
The initial submittal to the county from the city of Pasco was for 4,000 and something acres. I want to say 4,200 or 4,400, but I just can't, I just know it was over 4,000. However, they had not done the work to make that determination, and that's done through an EIS.
Well, I'm familiar with that part of it. My question is, why was this specific site? Because when you do a UGA expansion, you're supposed to use natural and consistent boundaries, and to go cut this out will require city development on two sides and a Lammard on a third side, with a well-used collector on the fourth side. Sort of like landlocking a piece of farm ground.
The city made its application, and based on the EIS determined, it did not need this property. The city cannot willy-nilly, they have to justify and show why they're expanding the UGA and the acreage count that they have and things like that. And when they did their EIS, their more in-depth analysis, it was determined that they did not need, by the city, not the county, it was determined by the city that it did not need that property in the UGA. The county could have, in theory, unilaterally put it in there. However, the county would then had to have done the same analysis, gone through the land use analysis and all these other determinations, and countered and showed and basically told the city, no, you will need this, because the expansion of a UGA is based on service provision. And if the city's plan does not plan to serve that area, it's at their discretion as to how they plan. So
kind of
they
along
cut
that-
it out.
Yeah, so kind of along that line of thinking, would the site immediately to the left of this on the map, would that argument you just made not apply to that property as well?
They desired and showed how they would serve that property, and they were able to, and that's why they included it. I'm not personally comfortable speaking to why the city made decisions that it made, because I wasn't involved in those processes.
Yeah, I'm trying to understand this body's responsibility of making this decision, and it sounds like that we have virtually no impact or influence on the decision-making process with doing something like this and cutting out a piece of property that is obviously, on a natural boundary. And so I'm just trying to understand this board's authority in doing this. I'm looking forward and then trying to look backwards and ask, why did we do this?
Well, like I said, in this case, it's because we don't control like, we would have had to have done the analysis. We didn't do the analysis because it was their UGA, their request. They didn't ask us to do it, and they didn't want to include it. Now, what is our position? What is our power with regard to making a change? Is that where?
Well, I'm just trying to understand, do we have, or is it within our authority or purview to ask them to include or to consider a property?
We can, and there was discussions, but the city made its determination based on whatever metrics the city uses to make its determinations, and decided they didn't want it in the UGA. The county, when it comes to annual amendments, we have adopted development code that states that this type of a action is probably more appropriate during the decennial update, due to the fact that when we're doing that, we'll look at all the land. And part of what we have to decide is, are we maintaining proper balance of agricultural land, because that's a primary focus for the county. And we have to make sure that there's a need or justification for the land being included or changed to a different purpose. And that requires us to do a full-blown analysis. We're talking tens of thousands of dollars for these studies. And that's why it's done for a collective analysis as opposed to individuals. Now, if a landowner or applicant would want to do a full-blown land use analysis for the county and pay for that, then it's something that would be potentially more appropriate for a annual or biannual update.
So the applicant on this, if we were to say no to this action, when is the potential that this could be brought into the UGA and potentially annexed into the city? What would be the rough timeline for that?
26.
So 26 is when the UGA expansion would potentially bring this in?
No. It's a matter of, I don't know that the city is going to be seeking to expand their UGA. They just annexed 3,000 acres.
So that's the time when it would be considered. 26 is the
But
consideration.
we could look, we will be doing a pretty hard dive, because we've got to look at some things with the county as far as what are our options, and making sure that we can maximize the potential for the county.
We do
So
the
we're-
UGA lines? Are we the ones that delineate the UGA lines?
No, the city does. I mean,
So
so they submit an application to us as an amendment to the county comprehensive plan. We take that, we look at their analysis, determine whether or not it makes sense, with their 6-year and 20-year plans regarding transportation infrastructure and elements like that. And their desire, the city is a free entity. They get to make their own decisions. And if they don't want something, we can't really make them
So,
take it.
so 2026 is when we would address this, but if they don't make the application, as you said, they recently, annexed more than 2,000 acres. So if they were, as 2026 comes, obviously those more than 2,000 acres will not be developed at that point. So it's unlikely that they would ask for this area to be brought inside the UGA in 2026. Is that fairly accurate?
I would say. Well, potentially. See, a lot of it has to do with, you got to remember, we're doing 2026, but we're also planning, okay, no, by 2026, it's not going to be there, but by 2056 or 46,
There's 6-year.
would it be there?
Yeah, the City of Pasco's 6-year transportation system master plan indicates them spending many millions of dollars on roads that are adjacent to this property. That's why I'm trying to understand the timeline and what the plan is, because they have plans of updating these roads
Right.
in 27 and 28.
And this process that we're going through coming up is going to be different than what's been seen here before. One, we will be working much more closely with the city. I don't know, all of that was done before I started here. I don't know what the collaboration was with the city, but
As far as the transportation system master plan or the UGA?
the whole everything. This is a type of document that needs to be worked in collaboration with your cities, because we need to make sure that we're working in harmony, or we end up with conflicts. And we want to minimize conflicts, because those just cost money.
I'm really, to really dial it down to what my question is, I'm trying to understand the, I'm a developer. I've developed, not this property. I've never had any interest in this specific property, but close properties. And the applicant in this case worked diligently and was assured that this was going to be brought into the UGA, and it was not. And I'm trying to figure out where the collaboration broke down and how that happened. There's people that were brought into the UGA that worked diligently to try not to be brought into the UGA, and there's other applicants such as this one that worked diligently because they wanted to be in the UGA. And I'm trying to understand the collaboration and the cooperation that did or did not happen between the county, the city, and the applicant, and trying to understand that.
And I wish I could speak better to it, because again, all of that occurred before I started here. And when I arrived, the city was already doing its EIS and had come to the conclusion, and then my understanding is the applicant and the city, they met with the city many times to try to get that changed. But I don't know what the city's position was as to why, I think, why they picked that one as opposed to another one.
Yeah.
I know that we were talking also on doing potential land swaps and things within the UGA and things like that, but they just didn't apparently come to fruition.
Thank you. Thank you, Mr. Chair, for the extended.
Yes, thank you.
If I may comment briefly, Commissioners?
Yes.
So I share Mr. Broughton's concerns regarding, are you gonna present on O2 as well? Mm-hmm. Okay. So I'll limit to O1 right now, but I guess O1 and O2 share the same concern that this would be an expansion of a Type 1 LAMR, which is prohibited by the Growth Management Act. And our comprehensive plan designates the rural residential zoned areas or land designations as LAMRs. So that's sort of the logical outer boundary. So there's a relationship there in our land use map, in these land designations, and the establishment of the logical outer boundary. So I just wanted to make sure that was clear. Yes, Commissioner?
So is the logical outer boundary, does it not encompass this property?
It does not appear, at least based on the comprehensive plan, because it indicates that the rural residential areas that were previously designated are Type 1 LAMRs. And so by defining it in that manner, that would strongly imply that would be the logical outer boundary, would be these designations. And so I don't know how you could expand those And that's not even taking into consideration the issues with the second application, which also appears to be an Altec, which has its own separate issues. And so this whole scenario kind of reminds me of a friend I used to have. He's not a friend anymore, but he'd always end up getting into fights. He'd pick fights, and it always seemed like I was the one that ended up, being in the fight. He'd be on his way, and this is that sort of scenario. I mean, the applicant here, and I understand they've worked diligently with the city to be part of the urban growth area, but they're picking a fight here with the Attorney General's office, and we're going to be the ones that are going to be end up in that fight, because ultimately it's the board's decision whether or not to approve these. And certainly, I mean, we could talk about it more in executive session, but there's really not a whole lot of nuance here that I'm seeing that that would really warrant that sort of closed session. I mean, it's not a gray area, in other words. And one of the things that has changed since the FutureWise appeal is that there's no longer this vesting loophole where, it used to be a comprehensive plan amendment went through, and then the applicant could just, or the landowner could just vest a permit because there's a presumption of validity once the zoning designation is changed. Well, now that presumption no longer applies for 60 days, which coincides with the appeal period. The AG has promised us in the most polite way possible that they will appeal this, so they'll sue us, in other words, to the Growth Management Hearings Board. And if that happens, then the change doesn't take effect until that appeal process plays out. Which again, it seems pretty clear what the outcome would be, but.
Mr. Chairman,
Yes.
so that appeals board, we've talked about them too. One's from the west side, one's from Spokane. There is no representation from our county or
Right.
This Growth Management Act, our ability to grow as we see fit. This to me looks like it doesn't follow roadways, or it's isolating one piece of property and keeping it out of the urban growth area. And this is an injustice.
Right, and as Mr. Broughton indicated, there's a relationship there between establishment of an urban growth area and the amount of land that can be served by the capital facilities of the city. Right, that's the purpose of the urban growth boundary, but also to accommodate the 20-year growth projections. And so it's some complicated math, I'm sure, and the city's looking at all the land they would need to accommodate that growth, as well as their capacity to provide urban services.
So
city-
in this case, those urban services, is that anything besides the road?
Yes. Yes.
What other services would they be providing?
And those can be phased in, depending on the need at the time of the development. But you're talking stormwater, sewer is obviously a big one.
So
and
that is
water.
not requested, and this action would not commit the city to any of those services.
That's correct, because it's outside of the city. So it would be very problematic for them to extend urban services outside of their own urban growth area.
So that's what my question is what services would this action ask the city for?
I'm not aware of any.
Okay,
Right.
because their transportation system master plan, which is the only thing that I'm aware of that would tie into them.
Right.
And they have made accommodation and allocated funds for that very purpose, and that's why I'm trying to understand where it appears to me that the existing Lammard that encompasses this property by the existence of the services and the UGA boundary and the city limits now and Clark Road. So it appears to me that this site is within that boundary of the existing Lammard. It would not be burdening the city with sewer or water services. They've already made accommodation for the roads to tie into this, and I don't know that they've budgeted funds, but they've certainly put it in their transportation system master plan. And I'm trying to understand how that the four criteria that we've measured are not met by this.
Right, and I think it's, again, we go to our comprehensive plan and look, and the rural residential is designated as the LAMIRD. And LAMIRDs are kind of like wildfires. You know, you want to contain them and stop the spread. You're not necessarily going to prevent what's already happened. People have, you know, rights to the property. And so we've sort of contained these areas in our prior comprehensive plan by designating them in this rural residential. Well, this area adjacent that we're talking about right now is not part currently of the rural residential.
And is that depicted on a map somewhere that shows what that is?
Yes, it's in our comprehensive plan. It's map 10.
Okay, can you go back to that next map? So this area right here is included in the existing LAMIRD as you just showed. So how is that expansion different than this expansion?
It's not an expansion. It's not an expansion. It's the existing, excuse me, sorry. It's the existing LAMIRD. That's the way it was defined. That's the way it's been. There was land inside that was not subdivided. If this were in the LAMIRD, prime example, Eltopia, Merle's Corner, and Basin City. They have they have a boundary, the LOB, that is, when you look at it, say you look at an aerial, you'll see developed area, right? And your logic will go, oh, that's the LOB, but actually it's not. In those areas, there's a box literally drawn around them, okay? Anything within that box can go through a zone change or be changed because it's got a designation of rural. It's got a specific designation that basically says this is what we're going to, I want to say it's rural commercial, but that's not right. Rural development, that's what it is. It's rural development designation. So let's say right now a piece within that box is a rural development designation, but it's AP 20, and they want to go to residential. That's what we call simple zone change, because in the rural development zone or designation, it states these types of uses are allowed. So you just go through. This is not in an existing LAMIRD or an LOB. It's adjacent to it. We always have a line. There's always a line, you know, where something ends and something starts. And that's what's going on here, is this LAMIRD was defined. Big part of why we have designated LAMIRDs is to ensure that landowners don't have to go through a bunch of hassle because they're technically on non-conforming lots, meaning out in the AP 20s, anything less than a 20-acre lot, unless it went through an innovative short plat process, is considered non-conforming. Well, back in the day, you could do 5-acre segs just through recording. We had a lot of those done. That's what these represent. And what happens is by us assigning a LAMIRD, when somebody buys it or looks to get a loan or something, there's no question as to the allowance of that, even though it's in this ag area.
When was the last time that LAMIRDs in Franklin County would have been adjusted or potentially adjusted? When was that last cycle?
My understanding, other than some movement with the shoreline development area coming in and out of the city, I think that these are the original LAMIRDs that were established at the time the county adopted.
So let me ask the question a different way.
The
If we were
AP
going
20.
to adjust them, when would we have adjusted them the last time? Would it not have been on
It could have been
the
in the
UGA
18.
expansion?
It could have been, yeah.
On that UGA expansion? So perhaps,
On the 2018 comprehensive plan update is when
Which
these
is-
types of actions.
that's when we did the UGA expansion, correct?
Correct.
So would the action that was taken then, shouldn't that have included drawing that LAMIRD around this property then?
No, because there was no request to expand the LAMIRD at the time. That is something that could be looked at in this 2026 update. That would require substantial land use analysis which we have to do anyways. So that's when, but you'll see in all the rules that we have to operate under, that I'm bound by, that expansion of existing landmerds is, I mean, it's like takes an act of God, it seems, to get those adjusted. The state has no desire for them to expand. There have been multiple petitions and requests to the state to give us a little bit more flexibility with what that is, and they've just been shot down, at least the last 3 or 4 legislative cycles. The counties have been doing a lot of work to try to get more flexibility in the landmerds, but unfortunately, we have not been provided with that authority.
But you can expand an urban growth area, which it's also next to.
Correct.
So that seems like a more viable solution. And our next comprehensive plan is due, is it June 23rd, 2026, something like that?
June 30th, but
June
yeah,
30th, Okay.
the end of June 2026. And we will kick it off. We start getting our funding in this summer. So that's when we plan to kick it off.
Isn't there an option today for the board, if they wanted to kick this back down to the planning commission?
They always have a right to remand.
Yeah. So there's a third option, I guess, as well.
But it's the planning commission to approve it. Is that correct?
I'm
Well,
sorry.
it would be to study the issue more.
They
Right.
already approved it unanimously.
They've already recommended
That's what I'm
approval.
asking. They've already approved it.
Right, but
Recommendation.
Unanimously.
it was, that's their recommendation.
That's why I'm just
Yeah.
asking.
Yeah, staff
Yeah.
doesn't agree with that recommendation. And it's unusual that we will provide a split decision, but when it comes to something like this, I have to stay by my position, my interpretation of the law, and my duty is to make recommendations to the board that I believe are in the best interest of the county, and that's the position I'm at. However, it
clear-
is up to the board as to what they want to do.
Clear and defined boundaries would be Clark Road straight across. I can't understand how this property got excluded. I know that the city excluded it, but then I'm hearing, I heard today that actually we're only talking about 80 acres because some of this was sold to the school too? Is that true?
Yeah, some of it would, but it wouldn't necessarily, I mean, that's not relevant. Ownership of the property at this time isn't relevant to the discussion. It's about the use. So I have not received any request to modify the application to remove 80 acres or whatever the amount is. I have to consider it as it is on the ground now. And even if it was purchased by the school district, it wouldn't change necessarily, well, it wouldn't change my recommendation. It doesn't change the dynamics of what we're dealing with. I'm not, again, I have a set of rules that I have to follow, and I have to make my recommendation based on those rules.
So the section that is cut out there, what is the total acreage on that?
To 162, whoops, 162.3.
All right, thank you.
So should we continue with the next presentation because we're going to either rule on 1, 2, or 3, or?
You'll make a decision based on whether you want to do, staff's recommendation, which is to deny, adopt both, or only one.
And it looks to me like we got one chance of this a year.
Parties can do an annual amendment
Yep.
when we submit, when we're doing it. We will be opening up our comp plan this year a little differently. It won't be the annual amendment process. We'll start trying to work with folks once we get the stuff going, so we have it early. And then we're looking at those applications as we're developing the overall plan. So that's kind of where we're at.
Can we continue with the presentation to proposal 2?
Yes.
Oops. CPA 2022-02, Underwood. So this is a request to change comprehensive plan land use designation of approximately 44.5 acres of land from agricultural to rural shoreline development, and the property is a designated ALTAC, agricultural land of long-term commercial significance, ALTAC. Parcel number is 124190232. It's bounded by the rural shoreline development Lambert to the west, which are currently active farming operations. Active farming operations to the south, rural remote Lambert to the east, and active farm activities to the north. Properties to the north and south have a land use designation of agricultural, zone AP20, and then rural shoreline development to the west with RC1 zoning, and rural remote zoned RR5 to the east. So this is the property. There it is in the county. There's a close-up of it right here. This is the RR5 Lammard, and this is the rural shoreline Lammard. This is Columbia River Road. There's a this the side. It's side because just the way it's the best way to look at the property. So it's kind of an odd shape, but rural shoreline, agricultural, RR5. Technical agencies notified on July 20th. Notices were mailed, and notice was published in the Graphic on the 20th. Property was posted with a sign on the 21st of July. Department of Commerce was notified as part of the 60-day review process on the July 25th, and it ended on September 25th, 2023. Planning staff reviewed the checklist, issued a determination of non-significance, which was recorded or filed under the SEPA registry number 202-303-411, and comments were due by August 3rd, 2023. No SEPA-specific comments or appeals were received. So again, this is a reiteration of the other same issues that we had with the previous one. I can go through those again if you want to hear them, but long story short, staff's analysis determines that this one, the same regulations apply. Lammards, the same RCW, and the same WACs for the most part. There is one distinct difference though, and that's that this property is a designated ALTAC, whereas the Olberdine property is not. So, 4 conditions counties need to address when establishing governing LOBs. Again, need to preserve the character of the existing natural neighborhoods, physical boundaries, the prevention of abnormally irregular boundaries, and the ability to provide public facilities and public services in a manner that does not permit low-density sprawl. Now, we have this issue regarding the ALTACs. WAC 365-190-0501 states classifying, designating, dedesignating agricultural resource land. Counties conduct a comprehensive countywide analysis consistent with WAC 365-190-04010. WAC 265-190-04010B2, or II. Counties and cities should maintain and enhance natural resource-based industries and discourage incompatible uses because of the significant amount of time needed to review natural resource land and potential impacts from incompatible uses. Frequent piecemeal de-designation of land should not be allowed. Site-specific proposals to de-designate natural resource lands must be deferred until a comprehensive countywide analysis is conducted. The county's comprehensive plan states the county should consider requests for de-designation only in connection with the urban growth area expansion requests and during periodic updates of the comprehensive plan. The next periodic update is due by June 30th, 2026. So this is the the map that designates all of our designated all tax. There's different types based on the color. These are range, usually kind of like rangeland types. I think this is really nice soil, and then the red are irrigated, and it can be a mix of soil. It's kind of the rough over there. It's much more detailed than that, but that's the rough and ugly of it.
Can you zoom in on that map?
Yep. The next slide is gonna show a close-up of that property. So we are talking about wait. Yeah, so it's this one here. So you have these. This is all
That
tax.
property there, correct?
Yeah. I'm sorry, did I hit that? That's the Lammert. I apologize. It's the close-up and the joy of pixelations. It makes things a little complicated. But yeah, it's this parcel here. These are all designated all tax. This is the shoreline development area. And that's the Lammert, the 5-acre Lammert. Did you have any particular questions on that?
Oh, how is this not the same soil classification in this and this?
It's this, I'm not saying it is or it isn't. I'm saying this is a designated Lammert, and this is the shoreline
Oh,
development.
I thought we were talking about all tax.
These red ones are all tax.
Yeah, that's why my question is, how is this not all tax and this is?
Because the county decided that they want this area to focus on residential development, most likely due to the value and proximity to the river. These lands, the county decided they wanted to maintain as agricultural lands. And that was the determination that was made when these were designated as such. Back in at least '08, I'm not sure exactly. I would hope it was done in '90s, '96, something like that. I'm not saying that that's necessarily represents what the current county wants to do. I'm just saying that's how these things are designated.
Ideally, those are not good farming parcels.
Again,
I mean, that's.
that's why,
they're
like
so
I said,
labor-intensive to
our
farm that.
comprehensive plan, we will be doing an analysis and determining if we've got everything laid out the way they need to be laid out, because a lot of the concepts that we are experiencing, or our maps and stuff, represent a paradigm that was different than it is today.
Wasn't there a canal going right to the north of that at an angle? Isn't that what that line is?
Okay. So, well, that one's not very useful. Well, I guess it is. We've got this line, that's Columbia River Road.
Okay.
That's not much better. All right. So, yeah, I'm pretty sure there's canals up in there. I think that's what these blue lines, but I'm not 100% sure at exactly where the canals are, but this is what we're talking about, this property here.
Would be on the east side of Columbia River Road,
Yeah. No, it's on the
west side.
Yeah, it borders the shoreline development area.
Okay.
So Fraser Road, it's bound by Fraser Road. And then this is the RR5 Lammert. And then this is the boundaries roughly.
Can you zoom in on that?
I don't know.
Or bring up a different map? That one works.
There. I thought I had a better map, man.
So
It was
there's a
stressing me out there.
There's a canal right here, and there's a canal here.
Okay, all right.
So you got a canal here, road here, canal here. So it's bordered on all four sides. I guess the fifth side would be a residence.
It's a residence or it may also be a
Farm shop.
farm shop or something similar, yeah.
You done with your presentation?
No. We already discussed that. Okay. So there are 4 properties including, no, that's not the right one. Oh, yeah, okay. That carry both an agricultural land. So that's what, it is surrounded by all tax except for the shoreline designation to the west. The other 2 properties to the north and south are all tax. So one of the things is that it was an oversight. The fact that the property is surrounded on all sides by all tax to us says, no, it wasn't an oversight. To us, that's an agricultural bridge that allows connectivity through all agricultural lands without having to go through designated residential areas. That's how we interpret that. So we do not believe it was an oversight. We believe it was intentional to maintain that land bridge of agriculture, to where it's not broke. Columbia River West Lammerd was basically created as part of City of Pasco's urban growth area. Then they kind of pulled back from it. It's one of our highest development areas as far as the county goes. Generally speaking, when developed, they're usually going for 1 acre lots, sometimes larger. There have been applications to look at creating half-acre lots, but again, under our current, it's not really the intent of that area to allow for. There are some in there, but they're kind of holdovers from back when that area was part of the UGA. So, basically calling it what it is. Some up in like Eltopia, you'll see properties that are zoned RC1 that are less than 1 acre. That's another thing I will be looking to address, is making our maps actually and our zones represent what's actually on the ground. So that's that. That's the Lammerd to the west. Again, same issues with the expansions of the Lammerd LOBs. These don't have that box around them that, like Eltopia, Basin City, and Merrill's Corner do, that you have land that these are specifically defined based on the zoning. Or I should say the land use designation. Rural residential to the west, rural residential development to the rural residential to the west, rural residential to the east. The request was to change for the addition of more single-family dwellings. We did a very basic analysis of the shoreline area. We have a vacancy rate right now of around 80%. So there's not like we have a shortage. And that's one of the justifications for expanding Lammerts and other things, is when we look out into the county and we find that we really don't have the availability of these types of lots. Then we start usually the discussion to determine whether or not we need to expand or create a new Lammerd, because we're at, like, say, of the Lammerts of 1 acre or 5 acre lots, we're at 80% capacity. And then if that ever happens, we need to start actively thinking about creating new opportunities and things like that. At this current point, again, so we didn't see a need. We see that we have plenty of land available for folks to develop a comparable type of development. So that we can't really use that justification for expanding the Lammerts, because the math just doesn't work. Now, the calculation doesn't take into account various limiting factors, this is just a raw analysis. Some of that property is going to be not developable due to proximity to the cliffs, the elevations, various other dynamics. But again, that takes a detailed analysis, which is part of what we would be doing as part of our comprehensive plan update. So this is a analysis of that, what we know or are on the ground or proposed or have at least heard a rumor about. So we have the same WACs involved, recognize that existing areas more intense rural development and to minimize and contain these areas to prevent low density sprawl. Zoning combined with the common low density residential starting at around. So again, this is more of our analysis. Basically, when we look at what's going on, we start seeing a de facto expansion of Lammerts without going through the proper Lammert process. This area isn't really planned traffic-wise at this point in time. Again, that's something that will come out in the comprehensive plan update. We're going to be doing much more extensive studies with regard to those things. So,
You back up one slide there, I was reading.
sorry.
So
Without that designated plan, we end up with potential for, you end up with pinch points and things. It's not.
I appreciate that, but
yeah.
this is not a project action. This is a land use action. So a non-project action would not create traffic, correct?
No, but we have to analyze the potentiality, and what happens in that type of scenario is you have to analyze it to the worst case scenario. And see, under ag, we know that it's only going to be at best, one unit, one per 20 acres, whereas at RC1, the impact to the roads would be potentially different.
But that
we have
impact
to-
is determined and measured at the point that that action is brought. This does not bring
No.
that action.
You are correct in some circumstances, or in those specific circumstances, it's always done at that time as well. But for a comprehensive plan amendment, just like with zoning, we don't do conditional zoning. In other words, you as or somebody as a developer goes, hey, I'm going to do X if you give me this zone.
So if the
You don't do
applicant-
it that way.
If the applicant, if this goes through and then later the applicant comes and provides a project, could they at that point then say, you've already analyzed the traffic impacts and that's already been dealt with back at the land use action?
If it matches up with the analysis that was performed, yeah.
So the applicant would not have to then at that point provide traffic impact analysis
I
and so
can't
forth?
speak to that because it depends on the specifics of the proposal at
So
the time.
are we not then asking the applicant to duplicate the efforts that they put forward? Because this is in fact a non-project action, so this does not generate traffic.
I understand what you're saying, and what I'm trying to articulate is there's a difference. And there's a required things that we have to analyze. When it comes to comprehensive plan amendments, you analyze to the worst case scenario. So what would happen if we used or allowed the applicant to use our study? It's probably going to be a lot worse than what they're actually proposing.
I guess I'm trying to understand why are we going outside of a land use action, not a project action? Because unless I'm misunderstanding, we're analyzing a project action, not a land use action.
No, but
Because this
and my
action,
response is speaking to a project specific. I'm just trying to make
that's
sure.
what it appears to me.
And what I'm trying to explain is that one of the metrics, one of the things that we have to analyze when we're looking at any comprehensive plan amendment, or for that matter, a zone change, is we have to look at the transportation elements. And the specifics will come out at the time of development. That's when we would levy things like mitigation fees or things like that. But also what has to be looked at is there any idea that we're going to do, because we have to look at, if we change this designation, what is the worst case scenario? And how will that impact things? That's just what same thing with zoning, you have to, when you approve a zone, you have to be comfortable with the idea that anything allowed in that zone could develop, regardless of what the applicant said they're going to develop there. Because once that change occurs, the owner of the property has the rights under that change, not what the guy before said he was going to do with it. So, along with infrastructure studies, water, sewer, those types of things, transportation is part of that analysis. And that's all we're saying. We're not levying at this time a fee or anything. That would be project specific. But we always take into account, when you're increasing potentiality of traffic and doing that, we're required to, under SEPA, to check to see what that impact will be. And when you don't have a specific project, you look at it and you go, okay, in this case, most intense development would be theoretically 42, reality 35, 37 lots, something like that. And that's how we would look and go, is the infrastructure there to accommodate that? Or is there plans for within the next 6 years, because we have a consistent or concurrency requirements. So, but that's, yeah, I mean, it's just another piece that support, why we made our determination is, again, we're looking at the overall look, and it's just not there yet. It's always a concern that when you develop piecemeal, that you'll end up with points in your infrastructure roadway system that aren't designed to accommodate that development pattern. They were designed to accommodate one thing, and it's just part of the analysis. Now, if not but for other issues, that would not have necessarily held up the proposal, because it's things that can be mitigated. But it's part of our analysis, and we wanted to make you aware that that's part of our analysis.
I did have a couple comments, if I may, Commissioners. So, I just wanted to point out, sort of reiterating everything about the Lammerts that was concerning with the last proposal, but because this is an all-tech and we're in agricultural land of long-term commercial significance, as Mr. Broughton pointed out, and we're effectively changing that designation, this would be a D designation. And so that's problematic for a number of reasons. Initially, there's criteria, de-designation criteria, that we would need to establish factually, which is difficult to establish. I'm not saying it's impossible, but it does present kind of a catch-22, I've always thought, because among the criteria is whether it's characterized by urban growth or has public urban facilities, and those things certainly don't happen if it's currently in all-tech, and so it does create a scenario where you're running into problems. Yep.
I do appreciate that. Can you tell us when this particular 2022-02, when this was originally submitted, when they began that?
I don't know, but that's a good question. It certainly leads into my second point.
So my question, the reason for my question is, have we not had adequate times? We have hundreds of pages in our packet in relationship to these two comp plan amendments. My question, based on your question, is, have we not had adequate time to analyze that specifically?
Right. And, well, it's my response is that it would be bigger than that. So to answer the question, it would probably most likely be during not the annual reviews, but during a more holistic 10-year review. I think they used to be an 8-year review. Now they're set on 10. The reason why I say that is because when you're designating and de-designating All-Techs, you need to do so holistically, so countywide, taking a look at all of your agricultural parcels. So that's sort of the second point, is not only have I not heard that we've met the de-designation criteria, but we've also not looked at it holistically.
And so can you speak to that, approximately when this would have come in originally?
You mean, when did they request the amendment?
Yes, when did they first bring this to the county? Whether that was the date of the, the completed application, but how long has the applicant been working on this project? Trying to get this action here before us today.
It's been a while since 22, since April 22.
So is that not adequate time to analyze whether or not this all-tac is appropriate or not?
It certainly could be. Again, I think we'd have to show factually how it met the de-designation criteria.
I appreciate that argument, but I'm asking, have we not had an adequate amount of time since April of 2022 to do that analysis?
It's a countywide analysis. It has to look
So
at
we're not
every-
allowed to look at it on a project basis?
If we want to spend about $30,000 to $40,000 on the analysis.
So the analysis of this property before us today would have cost us between $20,000 and $30,000 to do the analysis of whether or not this was an all-tac?
Because you can't look at a single property, you have to look at the entire county. So it's a
So
county.
the answer to my question is no, we cannot look at a parcel or a limited area to analyze whether or not an all-tac is appropriate. We have to do it
That's-
countywide only.
That's unfortunately correct.
So it is countywide only. So we don't look at anything individually. There's no opportunity for that. It must be countywide.
Well, not anything. Specifically, it's agricultural lands, mineral resource lands.
So I appreciate that. I understand what that is. My question very specifically is, we are not allowed, due to some law or regulation in place, we are not allowed to look at a limited area for the all-tax. We have to look, anytime we look, it must be countywide.
Correct. Yes.
Okay, I would love to understand that better, and we don't need to go into that today, but I would love to understand that better. Mr. Chairman, I would like to, I believe the applicants are both here. I'd love to hear from them. I'm sure that they have some information that we could further gain insight from.
So this is an open meetings, so is there anyone here that would like to speak?
Good morning, Commissioners. Peter Harpster Land Development, 9527 Sandifer Parkway here in Pasco. Here today representing the applicant, Diamondback Farms, Mr. Levi Underwood at CPA 2022-02. We're happy to finally be here, as mentioned. It said somewhere under 2023 comp plan amendment. It's 2022, was submitted in April of 2022. Been almost 2 years. So despite the delays, we are excited to be here this morning and have the opportunity to come before you commissioners this morning for this legislative item, of which the Planning Commission of our county recommended approval. First off, I take issue with the offensive characterization of picking a fight by submitting this application. It's our client's right as a landowner to submit a comprehensive plan amendment application according to Franklin County Code, which is what they've done. I do want to mention that notices of the hearing today in this application, as well as the other application, went to 1,700 residents in Franklin County. You may hear from a few of them today, and as Mr. Bratton stated, evidently there were 7 comments in opposition. Theoretically, that would mean then that several hundred are in favor, well over 99%, including the landowners most closest to this site, including Mr. Henry Field, who owns really the only truly adjacent property right below here where a road does not, a public road does not intersect the property.
This property here?
Yes, sir. Mr. Field is not able to make it today, but he did want to pass on that he is in favor of this application and said any of the 3 commissioners can call me to verify. Of course, we would like a vote today, but if you did want to verify with them, that would be fine. I also want to make clear for the public's sake that, again, there's no project before you today, and so comments regarding water, traffic are irrelevant at this time. If a landowner wished to develop his property in the future, then it would require separate applications to be submitted to the county. Mr. Bratton's staff would review them and coordinate with that applicant and landowner, and we'd go before the Planning Commission again, before the Board of County Commissioners again. There'd be a lengthy process. That's not what's being reviewed today. As stated, this item went to 18 different agencies for comment. Only 2 responded. Franklin County Public Works had project-specific comments about traffic. Those, like I mentioned, would be more appropriate to be addressed in the future if the landowner brought forward another application. And then lastly, the State Department of Commerce was the only agency to provide comments in opposition. And the comments made this morning, we weren't invited to any opportunity to coordinate with the State Attorney General's office, and so I can't speak to that. Lastly, you'll hear from the rest of our applicant team today, which includes Mr. Rick Simon, planning consultant, and Mr. Mark Fickus, a land use attorney. And I just want to thank you for your time this morning, finally hearing this application, and giving our clients, the Underwoods, the opportunity to be heard. And our ask today is that you would consider the Planning Commission's recommendation of approval and vote to approve Ordinance A. Thank you again for your time today.
Good morning, Mr. Chairman, Commissioners. My name is Mark Fickus. I'm a land use attorney from Yakima at the Halverson Northwest Law Firm at 405 East Lincoln Avenue. I'm here on behalf of Diamondback Farms, a farming entity owned by the Underwoods. This is a small community. I'm sure you know both applicants, the J11 and the Olberding. This is sort of a weird. This is a culmination of a 2-year process. To be honest with you, as Commissioner Baumann said, shouldn't be a 2-year process. I do comp plan amendments all throughout the valley, and there's 2 ways to amend a comp plan. One, as Mr. Bratton and Mr. Briggs indicate, through the mandatory periodic review process that's now 8 years. Franklin County's on a schedule. But another one that's just as viable is the annual review process. And I'm going to go into, I disagree vehemently with the strict interpretation, reading the Growth Management Act as a straitjacket to Franklin County, to where you can never have residentially zoned property and housing outside the urban growth area. That's just wrong. It's done, and I'm going to tell you why in a second. Again, these are a 45-acre tract surrounded by residential development, and a 162-acre tract going right next to your new high school, that half of which is being brought by the zone. The annual amendment process is there to correct errors and allow for corrections when there's been a substantial change of circumstance. You guys can, the record's been created over 2 years. Building a high school next to a farm or being surrounded by a residential community and having development occur is a change in circumstances. These properties are not suitable for farms, and I'll get into the all-tech, non-all-tech distinction later. One thing I'd like to point out, again, normally I appreciate Mr. Bratton. I've worked with him for clients over the years. He does a good job. This one, I'm in vehement disagreement with him. Number one is this is a legislative non-project action. It's a public participation element of your comp plan. It should be allowed. Every county in the state allows annual amendments, and this should be the culmination. We don't need to send it back to the Planning Commission. In fact, one of my objections today is, I'm going to try to say this nicely, but there's no nice way to say it. Mr. Bratton's planning staff recommendation is irrelevant. It's not needed. It was needed at the Planning Commission level. He did his job under your code, under Franklin County Code 1470. We're going through the exact process that you guys adopted. When it gets to this stage, the findings he should be presenting to you are the Planning Commission's unanimous recommendations, not his. Again, Derek believes he's doing his job, and he's getting some input now from your new county attorney, Mr. Briggs, which is fine, which is the way it should be. But again, this process should have been wrapped up in the same year it was presented. I think you asked why it took so long, Mr. Baumann. I believe it was in part due to the FutureWise litigation and the impact on whether these were agricultural resource lands, i.e. agricultural lands of long-term commercial significance. So anyways, we're here to ask that this process be wrapped up. We don't think what's being asked to be approved is illegal. Your planning commission didn't think it was illegal. There will be people that, attorneys can disagree on how to interpret the law, and that's what we're here for. I'm disappointed to hear an implication that your planning staff and the city attorney already have talked to the AG about a potential appeal, but that shouldn't influence your decision. You're the legislature. You want to try to comply with the law. I'm going to give you a reason why I think you would be complying with the law to approve the comp plan amendment before you today. And if it gets appealed, that's why attorneys are in business. Diamondback Farm CPA, I'm going to deal with the 800-pound gorilla in the room. And by the way, it is confusing, even for attorneys that do this. I've been doing land use work for over 35 years in the county. And I disagree. The question is, can you de-designate agricultural resource lands through the annual comp plan amendment process? And I believe the answer is yes. And while there is some regulation language that is confusing, and none of the regulations that Mr. Bratton has stated are wrong, I'm just interpreting different. There are, under the statute, the Growth Management Act itself expressly allows, again, counties to adopt annual comp plan amendment processes, and they don't say you can amend your comp plan except for agricultural resource lands. They don't say that. There's nowhere in the statute. You have adopted Franklin County Code 1470 that allows annual consideration, and there's nowhere in there that says you can't submit a comp plan amendment if your property is designated as an All-Tech land, which, by the way, the J11 property is. It's not there. Now, there is some more stringent de-designation criteria that I won't bore you with, but I'm going to go through briefly. Contrary to Mr. Briggs, I participated in every hearing relevant to this. In fact, if you remember, I was before you initially when we were arguing with your planning staff on whether to even put this on the docket and accept their application after a year and a bunch of money. You sent it back to the Planning Commission. I was there at the Planning Commission. The application itself goes through the de-designation criteria. There is factual findings sufficient to support a de-designation here, and your Planning Commission unanimously thought that was the appropriate. You hire them to do a job. You can disagree with them. It's your decision. This is a legislative action, but there has been an extensive record prepared. So there is no reason to remand this to the Planning Commission. That's a lay body that doesn't have access to the experts that you guys do. That would be a complete waste of time, both yours and the applicants at this point. So we're going to ask you to, I appreciate your planning staff doing 3 alternative ordinances. That's a little weird. My recommendation on behalf of J11 would be that you adopt the ordinance approving Comp Plan Amendment 2022 separately with the by adopting the Planning Commission findings as supplemented by the findings that Rick Simon and I have prepared for you. They're part of the record. They're a little bit buried. I would cite to you the page number, but your planning staff didn't paginate the 300-page record before you. But there's a January 25th letter where we provided some supplemental findings that we think are consistent with this record. I'm not adding anything new. This information is before you. So, again, and the annual amendment process does have a requirement that sort of protects you from a parcel by parcel. It says that you have to consider all comp plan amendments submitted in 1 year at the same time to review its cumulative effects. I'm going to throw out a compliment to you guys and the planning staff. You've done a pretty good job with your Growth Management Act. You are a rural county with, 800,000 acres, 90% of which is ag lands. And in 2 years, you've only had 2 comp plan amendments. They're the 2 that are seated before you today. And Commissioner Didier, I have the same problem that you did. Factually, to have these properties, both of them remain ag lands, is frankly ridiculous. It doesn't meet, and I'm going to go through the de-designation criteria. These are only 45 and 100, let's just say, let's round number, 200 acres out of 755,000 acres of ag designated land that you have. This is immaterial. The consideration, if you look at the cumulative impacts of the 200 acres on the ability to provide, long-term commercial farm land, there is no impact. And again, I believe you can de-designate land during the annual amendment process. It is hard. The criteria in the WACs that were adopted by the Department of Commerce do require some additional consideration. And again, I'm going to go through those quickly because I know you guys are bored of having lawyers talk to you, but I disagree vehemently with staff and legal counsel's position that you cannot even process these applications, that they should have been, frankly, turned down, apologized, and not processed at all. I think the county, you can have rural transitional zones that allow low-density residential development transitioning between the urban growth area and ag land. That's done all the time. And I'm not even going to get tied up in the Lambert. I disagree. Nobody's asked to expand a Lambert here. That's your staff's interpretation of what's being asked for. I'm not asking, J11's not asking, Diamondback Farms is not asking to expand a Lambert. All Lambert is a crappy term from Seattle attorneys that when growth management was adopted in 1995, it was where did you already have residential housing? Where did it exist? And you draw a line on it. We're not asking to expand a Lambert. We're asking to have a rural shoreline development transitional designation between where 80% of my client's property is surrounded by existing residential development and planned residential in the future. It's where you as a county, a lot of your residential development is occurring in this, northwest of Pasco's urban growth area. So, again, nobody's been at a project stage. It's not appropriate to determine all the available infrastructure. There's a lot of limitations on projects, whether you can get water, whether you can get sewer, whether on-site septic. There are limits that make it difficult to do high-density residential development in counties, and that's not what we're talking here. But that can be done later. But it's strange here after 2 years to be being told by lawyers and your staff that this is illegal. I just don't think it is. I hope the state doesn't need to get involved to harass Franklin County. Their jurisdiction, I think, is limited on appeal. Normally, they only get involved in area-wide issues, not small issues like this. But that's nothing that we can control, and that's not something that you can consider, in my mind. This meets the de-designation criteria, and these are cited by Derek, cited by the CTED letter that you have before us, and I understand the Community Trade and Economic Development would like this denied, not on substance, but mainly on procedure. They're saying it can't be done. I disagree with them. The de-designation criteria is in 365, 190, 040. There's three simple things. They're looking, has there been a change in circumstances to the comp plan? That's not really applicable to my client's application, but these two are. A change in circumstances to the subject property and/or an error or failure to designate. That's why you have annual comp plan amendments, to be able to correct things. It's hard in a county this large to get every property line correct. There has to be some flexibility, and the flexibility is more than just sit there for 8 years during the periodic review process. And I think there's been a change in circumstances applicable to the property and/or error. And again, I'm going to stick to the Diamondback Farms application. So we meet that designation criteria. Also, it's in 365, 195, 050. So, the oversimplified, when you're de-designating agricultural resource lands, you look at the same criteria as when you designated them in the first place, and there's just 3 simple criteria. They're broad. Yes, Mr. Baumann.
Would you quote that WAC again, please?
Yeah, the WAC I was citing at first
365.
was 365, 190, 040, in parens 10, and that's the de-designation criteria for ag resource lands, and there's also some criteria in 365, 190, 050. It's in A, B, and C. Again, we're both citing this. I'm dealing with the substance of considering them, and you look at is in de-designating or designating lands. You look at, is it characterized by urban growth? Will the land be capable of agricultural productivity? And does it have long-term commercial significance? As applied to the Diamondback Farms land, it's all surrounded by residential or heading to more urban growth. It's increasingly incapable of being farmed. You can't use aerial applicators. You can't get a whole wheel line in there. You're gonna have conflicts with your existing lammards, although, again, I'm not expanding them. You're just gonna have conflicts, so it's increasingly incapable of agricultural production, and the land no longer has long-term commercial significance. That can be considered in your annual review process. And, playing out logic, it's silly. I don't think you need a county-wide study on 800,000 acres every time you come in with a half acre that can't be farmed anymore. That's a silly interpretation. That's what CTED and your planning staff's interpretation is. I disagree with that. And I'd be happy to help support your position in a growth management hearings board appeal if that becomes necessary. So I'm going to end. I won't going to get in the weeds. Maybe there should have been some additional consultation up front with planning staff and legal counsel, but we're here today and it's time for a decision. It's unfair to my client. It's unfair to the other applicant, J11. And this is, I've never seen a county view the Growth Management Act as a straitjacket like your planning staff has interpreted. These annual processes are normal. The only thing that's not normal is taking 2 or 3 years to do the annual amendment process. Normally there's deadlines that, frankly, you have to meet. And even the periodic updates seem to be taking 4 or 5 years beyond the deadline. And by the way, that's getting harder because you don't want to be out of compliance because you can lose funding for your roads from the state if you end up being outside of GMA compliance. The last comment I'll make is there are the other thing that's hard in growth, there has to be some flexibility because while we're focused on preserving and protecting ag lands, which you should, that's in the statute, that's in the WACs, I get it. These lands I don't think are no longer productive ag lands, but they're inconsistent with almost every housing policy that you have in your comprehensive plan. How do you supply flexible, affordable housing in the county, which is outside the urban growth area, if you can never use what was once farmlands for that purpose? You're a rural farming community, and you have to be allowed to provide housing. Not everybody wants to live in Pasco in a 0-lot line townhouse duplex. You can have some. Now there are, full disclosure, there's infrastructure problems that make development expensive and difficult. But let the market, let your patrons, let your voters determine that. Don't let people from the west side of the mountains, from the Community Trade and Economic Development, tell you can never have housing except once every 10 years. That's just dumb. And then the final thing I'll say, there are a few people opposed to that. Frankly, the neighbors that oppose to that, my understanding is, don't live within miles of it, and they're concerned about protecting their homes, not about preserving and protecting ag lands. So I think overall, just having a few people opposed to a comp plan amendment is actually a success. I think on this record, the 2022-02 application of J11 should be approved. The ordinance should be approved adopting the Planning Commission's findings as supplemented by the findings I presented that deal with some of the designation criteria that is all based on the record before you that was adopted in multiple hearings. So if anybody has any questions, I'd be happy to
Yes.
answer. Commissioner
I have a
Didier.
question. In the background of this, it says the Washington State Growth Management Act allows comprehensive plan amendments only one time per year. If we were to try to pass these separately, in your opinion, would only one be accepted?
No, they have to be, you have to consider there's only two that were submitted in the last 2 years. You're considering those together. They were docketed properly.
If we pass them together, but if we pass them separately, would only one be accepted?
No.
Docket
No,
is
I
the
think
change.
you can pass them separately. I probably think you should because there are factual differences between the properties. As your attorney, Mr. Briggs, stated, the property of Diamondback Farms is an agricultural resource lands. It is designated prime land. So my preferral, you can adopt an ordinance on each one. You've complied with the procedural aspects of the law by considering all comp plan amendments at one time. That's all that's required.
Yeah, the one change is everything contained within the docket. So there, you could actually have multiples, but it's the action. It's the action of approval, I think, that,
I wanted clarity on that before we made any motions.
I think the
or
two
did-
ordinances should be adopted separately, although I appreciate Derek providing an easy one that say they're both approved. I don't think that's the way it should be done, especially if your county attorney and staff are right that the AG's office is looking at appeal. There may be different issues associated with both.
So, option A would pass them both together. And what option are they individually?
B is 01, C is 02.
So my request would be that C be approved, adopting the Planning Commission's findings as supplemented by my January 25th letter that's in there. Rick Simon and I have drafted findings that we think were consistent with the Planning Commission's recommendation.
A has all the findings of fact and for both of the items, and then basically A or B and C are A broken apart
Yep.
with, the titles and stuff reflecting the
So-
reality. So
So
they're
A
kind
would
of
do
the same
the action
document.
together. B would do the Oberding's property with all of its,
By
including all of
itself.
its documents. It would pass it alone. And C would pass the Diamondback Farms with all of
Alone.
its findings of facts together alone. So
Correct.
B and C together would be equivalent to A, but it would take the action individually.
If you were, so the way it was put together is if you wanted to adopt both of them, you could just use A. I also do understand what Mr. Fickus is saying. If there's an appeal, say, on one but not the other, it may be easier to utilize the B and C.
But in that appeal, if they were turned down, it would turn down our motion, correct? To pass them both at the same time?
If it were appealed, if we passed A and it were appealed, would that then negate the action on the second one, the second item?
That's what I'm asking.
I don't believe so. It's just normally, in my experience, that.
You take it individually.
Yeah, you take them individually to allow, and the action doesn't become final for 60 days. There is a 60-day appeal period to the Growth Management Hearings Board. So I haven't seen them adopted when you have, some, by the way, the city of Pasco, my understanding, had like 10. I've had counties that on an annual may have 10 to a dozen comp plan amendments. They don't have to be all adopted. You don't have to make an all or one. They could all be different. Some are industrial, some are residential. So the only thing that's required, and it's required is the cumulative effect. If we had 10 de-designation requests of ag land including 1,000 acres, you guys could say, wait, the cumulative impacts of this are too great, while we might, that's all that's required by law. So I think it's cleaner to adopt ordinances, if you're inclined to adopt ordinances approving each one, that they'd be done separately with the findings that are consistent with your own county code.
And it's been done where it's, we have the same number with a letter designator. So, I tried to provide you with the maximum flexibility for you to make your decision.
And And the Planning Commission findings did a pretty good job. They hit your 6 general approval criteria in 1470, 110. Again, Derek did those a little bit begrudgingly because he didn't support them, but the supplemental findings that I prepared deal with the de-designation criteria that Mr. Briggs referred to that was discussed at the Planning Commission hearings and is certainly supported by the application. So, thank you.
Thank you.
Again, just to reiterate, we do not have a county-wide comprehensive analysis of our agricultural lands, which I'd stated was required. It's the WAC is 365-190-050, subparagraph 1. In classifying, designating, and de-designating agricultural resource lands, counties must conduct a comprehensive county-wide analysis. I haven't heard that. I've heard a
Would
lot
you
of
cite that
discussion of one
RCW
parcel.
Is it WAC or
with a crop
RCW?
circle on it, and why we can't.
You give it to him again.
Oh, sorry. WAC 365-190-050, subparagraph 1. So this talks about that we must conduct a countywide comprehensive analysis of our agricultural lands when we're considering de-designation. So we can't focus myopically on one parcel. We have to look at everything. And while I understand there's concern that this land may have been designated in error or is no longer capable of being farmed, or that there's a school nearby, so it's not capable of being farmed, we would need to look at this holistically. I also don't agree with the notion that just because something is a non-project action, we don't look at future actions that are going to be a result of that. The SEPA is very clear that even when there's a non-project action, we should be considering connected actions. So those are actions that are a foreseeable result of a non-project action. So to say, well, we'll just look at these things down the road when the project permits come in, that's not consistent with state law. So, and I know the applicants took umbrage with us discussing potential litigation with the Attorney General's office. I'm not aware of any requirement that we would have to include the applicant in these discussions or any sort of violation of any ethics rules or laws, but I would be certainly receptive if they could cite to something.
If I could add.
Yes, go ahead.
Thank you, Chairman. We sat down with the Commerce Department. It's not speculation. They sent, I think, four different members of the Commerce Department to come tell us in person they will definitely sue us the minute you approve this or appeal it. It will be expensive, and the analysis of your planning department is that we will lose. It doesn't necessarily mean the fight's not worth it, but just know that it is making an expensive decision to approve this.
Thank you.
And we have Mr. Davenport here, Steve Davenport with the Department of Commerce.
Yes.
I'd like to know the relevance of this, please. Is this for public comment with the open record?
It's a public hearing, and I think under our code, the director, the planning director, can include witnesses or persons to testify before or.
Are they here on behalf of the staff of Franklin County?
No.
They're here as public comment. Okay, I don't think we're there yet. We're not ready for this part. I think we're,
We have one more person that would like to speak.
yeah, the applicant's still going.
The chair recognizes the applicant to speak.
Thank you, Commissioners. My name is Rick Simon. I'm a planning consultant speaking on behalf of Diamondback Farms. So I'm going to keep my comments very brief, but just point out to you that long-term, this property, I think, is pretty clearly not suitable for farming. There's less than 18% of the perimeter of the property that is adjacent to existing commercial agriculture. The rest of it is adjacent to existing residential development or planned residential development.
Did you say 18%?
18%, yes, sir. Under GMA, there are a whole wide variety of goals, some of which, and many of which do, in some aspects, conflict with each other. So you have a goal that says the county should preserve its agricultural land base. You also have another goal that says you need to provide adequate supply of land for housing and for affordable housing. And there's several goal and policy statements included within your plan, and those are addressed specifically in the supplemental findings that we have included in your record. I'd say when you look at reducing the amount of farmable land in Franklin County by this approximately, well, in total about 200 acres, that represents a 0.02% decrease in your ag land base. It represents a 1.5% increase in your rural housing. And I'd say in this particular instance, rural housing is more important. The plan itself says that there is a need over the next 20 years for 2,305 rural housing units. Those are houses outside of city growth boundaries. Your staff prepared some analysis on the adjacent rural shoreline development areas that are largely vacant and suggested that there's maybe a maximum capacity of some 1,100 units that could go in there in the future. That only represents a little bit less than half of that total demand for rural housing. Certainly, South Franklin County is a place where most of that rural housing demand is going to be felt. This property would help alleviate some of that demand over the next 20-year period. It's well suited for that in terms of its proximity to schools and shopping and jobs, with its proximity to the Columbia River Road. It doesn't have any environmental issues that would preclude development of the site. I mean, there's no steep slopes, no identified critical areas on the property, so it's well suited for that purpose. And finally, just to go off a little bit of what Mr. Fickus said in terms of the annual amendment process allowing for this dedesignation, there is specific language in that WAC 365-190-040 that allows for the county to make a change acknowledging an error in designation. And again, county has over 35,000 parcels and 800,000 acres. There's only two landowners that have come forward and said this is needing to be changed, which suggests a very good job in the original adoption of the plan. But if you take the staff's position that these oversights can only be accommodated every comprehensive plan review, that's every 8 years. So landowner has to wait 8 years in order for this issue to be fixed. It should be done now, and it makes sense to do it now. It's the right thing for the county in terms of its housing supply. It doesn't have any impact on the ag land basis. One final comment, or actually two. One, part of your record includes determination of non-significance that was issued for both of these proposals, so that environmental issues have already been addressed for this process. If you approve this, there'll be future environmental review when projects come forward before you, but for now, the environmental questions have been answered. And then finally, the question about whether or not a road transportation plan needs to be updated, it probably does. Given the large vacant land within the rural shoreline area, as that develops, that's going to put more demand on the local road network. That can be accommodated in the upcoming plan amendment that's being done. this property is not going to be developed out fully in 2 years, so there's not going to be an impact that's not anticipated. That can wait for the 2026 update cycle. So appreciate your comments, or appreciate the opportunity for me to comment, and be happy to answer any questions should you have any. Thank you.
The 18% adjacent to, could you point out which spot, which area that is?
That's the southern property boundary.
And
There are like, I think, 1.15 miles of
boundary. So I believe Mr. Harpster pointed out that that landowner is in support of this action. Am I correct in that?
Yes, that's correct.
Thank you.
Thank you.
Thank you.
Eric, would you bring up Overton's deal for me? George Dockstutter, Desert Hills Realty, here to speak on behalf of Fred Oberding. As all three of you know, this has been going on for a hell of a long time. It goes back to 18 and went down to make the initial zone change application with Derek in 21. And we could not do that. We had to wait till 22 because of the time frame. And I've got several questions. I've done zone changes in this county and Benton County, the cities, for 45 years. And I've yet to see, this is the first open hearing after it's been unanimously approved by the Planning Commission. It's always gone to you and been a closed hearing in the past for your adoption or disapproval. I don't know why we're up here having an open hearing. At the Planning Commission, two people showed up, Miss Cindy Muse and the guy from Spokane. I don't know how in the hell he found out, because he sure as heck doesn't read the graphic. So somebody on staff had to tell him to come down and speak his piece. Otherwise, why would a government employee leave Spokane to meet down here at 7 o'clock at night? So one of the questions I've got is, why are we having an open hearing? And then back to Fred's, this process has been going on for 2 years at the county level. We're not asking for an expansion of a Lambert. All we're asking is for a zone change. The west half of that property is sold to the school district for a new middle school and a new grade school. We're down to 80 acres left. We're not asking to span Clark Addition. We're not asking for services because they're already there. Fire district, EMTs are right over there in the right-hand corner of the property. There isn't any services needed that Mr. Oberding isn't going to have to install himself to develop the property. So, like I said, this has been going on. I keep talking about it, but you've all heard me bitch about it in the past. We need to get this approved and need it done today. Thank you.
Thank you.
Regarding how Commerce got involved is because under state law, I have to send a notice out to Commerce for 60-day review. That's where they got involved. So that question's been asked a few times of me, so I want to make it clear that the process is that anytime we amend development regulations, we submit them to Commerce for review. Commerce contacted us.
All right, thank you for the answer.
It
Clears
was
things
not
up.
us.
Sure, no, thank you.
The answer to the second piece is that it's a comprehensive plan amendment, so it's not a zone change. If it were a zone change, it would need to be denied because the underlying comprehensive land designation doesn't allow for the zone that the applicant has proposed. And our code provides for a public hearing at this stage because it's a legislative act.
This comp plan amendment would be the first step. A zone change would be the second step.
Correct.
And then that proposed zone change would put this, it would allow them to make 1 acre lots. Is that correct?
whatever zone change they went for, yeah. But it would have to be a residential.
Thank you.
Mr. Oberding, the chair recognizes your opportunity to speak.
My name is Fred Oberding. I'm the landowner of the site that's up there. And did I see a red little?
It's the red one. We'll get the laser on.
Oh, thank you. To give you guys a little history there that don't see on the map is, and if it wasn't been brought up by Mr. Didier today, there's not a lot of people know that this quarter section has already been sold, paid for, and recorded at Franklin County as a sale to the Pasco School District. Within the next 30 days, that quarter section there is going to be sold to the Pasco School District. And that leaves me as the landowner or farmer operator.
What are you looking for? Which one are you looking for?
That same map. I'm sorry.
Oh, okay.
Hit the wrong button.
You're all right. Oh, now I gotta chase it. No.
This over in here leaves me as a farmer landlocked by a potential school, housing that's going to be developed on the south end of that, the existing Clark addition, and to the north, Clark Road. And I was going to point out that on the north side of Clark Road, the original UAG included a lot of that roundy ground. They didn't want to be in the UAG, and that's why it was removed. And my Circle J11 was in the original UAG, and when we had a hearing on that, the Port of Pasco, particularly the airport, expressed dissent because of plans down the road to extend the airport. And personally, as a resident of Franklin County, I could see why they wanted to take out about 30 acres approximately in the fly zone. And so what I did to attempt to appease them, I gave them an air easement. About that area there, because they need a longer runways, and it's something they're choosing to do down the road. And I says, well, why are you opposed to that? And he says, well, if it gets developed and there's houses there, and all of a sudden one day we wake up and there's 747s taking off over your house, we don't want to hear the complaints. I says, well then, if I granted you an air easement, that way when somebody bought ground out there, it would show up on their title report. Then they could choose whether or not to buy or sell or take it, or understand that airplanes are going to fly over here.
What was your motivation for providing them that easement?
Well, as a resident, lifelong resident of Franklin County, I don't want to stand in the way of progress.
So you were doing it as a good neighbor, you were not compensated for that air easement?
I was not compensated whatsoever. And, but I knew it was going to happen or going to come. And this, to me, this was the best solution, so that everybody down the road, I'm long gone, that puts a house there, will understand that there is an air easement, and deal with it or don't buy the property. And it's
So with the school district going in there for the good of the public, that adversely affects your your ability to farm the other 80 acres. Is that correct?
That is correct, because
And the air easement actually probably would lower your value that you're not being compensated for. Is that correct?
I would agree with that. But I've already been told by my aerial applicator that they'll no longer fly
Service
that
that
piece
area.
of property.
Yeah.
It's and one of the reasons that motivates me to try to get it into residential is, as a farmer, every time I put an airplane in the air, which I can't do, or a ground rig, or a water run application, I don't think I'll see an end to the amount of lawsuits that I'll be under. And I don't really, at my age, want to spend my time in court or litigating.
Mr. Oberding, I'm familiar with this area. That picture shows it in a crop of hay. I believe I've seen it in corn and potatoes and a number of other high-value crops. Would you speak to what the actions that have been taken to put, the city bringing this inside their boundaries and the UGA being adjacent to it, the schools and so forth? Would you speak to what, if this action is not taken, how will that impact your ability to farm that? We talked about, the ability to aerial applicate and ground applicate. What other restraints? Will you still be able to put hay and corn and potatoes and so forth on that?
Well, I can raise any crop as long as that crop doesn't require that I provide some kind of pesticide application to keep the diseases or the insects or the weeds out of there. That'd be great, but I'm not an organic farmer, and I rely heavily on those chemicals in everything else that I farm.
When the UGA expansion was happening and when those lines were being drawn, would you speak briefly to the interaction with the county and the city in drawing those lines, and whether would you just speak to that portion of it?
Well, when they originally drew the lines, and if I'm miscorrected, but it included that circle and what would be up along that line. That was some of the original ground, including my circle J11 in the original UAG, but then they needed to lower the acreage they were going to allow or have a fight with the state or FutureWise or whatever. They moved it to the south side of Clark Road, which still included mine. And the other thing that I might point out is from this point to that point, there's already a road easement for Road 52. But from there to there to the start of my boundary to Clark Road, there's not a road easement.
So that's a part of the transportation system master plan of the city of Pasco that they have allocated. That will be budgeted in 27 and 28. Have they approached you about easements or doing that? Was you a part of that transportation system master plan?
They have not approached me whatsoever, and in my personal opinion, when I think about transportation east and west in this area that we live in, there's not very many alternatives, and you either have to go to Sagemore or Birch, because the way that the expansion of what the port's doing with the Dairy Gold plant and that area out there, there's just no end in sight of what's going to be developed out there. And people are going to need residences, places to live, to work out there. And this location of mine is within 4 miles of all that industrial planning that's going to go out on the east side of the railroad tracks. Any questions?
No further questions from me.
Thank you.
Thank you.
Hi, my name is Marla Marvin, and it's confusing to me, the order of things. We had public comment, and then we had this conversation, which was members of the public who are also representing the landowner. So I'm not sure it's public comment period now.
It's an
for
open meeting,
these-
so you're,
Well, have we heard from all the applicants?
are there any other applicants who wish to speak?
Because then we'll transition into, you'll make a call for, is there any members of the public here to comment on that? That's usually the,
Is there any further landowners that would like to speak? Hearing none, I'll open it up to public.
Thank you. I'm Marla Marvin. First commissioner meeting I've been to. It's been interesting. Thank you. Not as interesting was the hours I spent trying to understand these sorts of actions. But actually, that's not true. I had never read the Growth Management Act or the WACs that support it, and all these acronyms were challenging. And so I get why only a few of us commented on this. I would say there's a 50-50 chance that the people, well, probably not even 50-50, but of the people who didn't comment, that they didn't comment because they supported it versus that they did not support these actions. I think that's a stretch to say that if they didn't comment, they supported. But that's a a matter of personal, a guess. It's a guesstimate. Two things. Most important, I think, is you really should split these actions. They're too radically different. The fact that two different landowners ask you to amend your comprehensive plan at the same time is all they have in common. They're not in the same area. They make, as the landowner just said. I mean, I got to say, I suggested you reject this one in my comments, but I don't know. I think this makes some good sense that you should maybe approve this one. I don't know. I drove by there and it looked like it could easily be expanded. That said, and the reasonable people could agree on the interpretation of those four Lambrid characterizations. I think that makes sense. So, not that it matters what one member of the public thinks, but they're so very different. The expansion of the second, the O2, just doesn't make sense. It clearly should be considered in your comprehensive land use plan. And this idea that it's been 2 years since somebody submitted their application and that therefore the county staff should have gone out and done a comprehensive analysis of whether we should change farmland to support this one person's request. I don't think we want to, I as a taxpayer don't want county staff spending money doing a comprehensive analysis every time anybody wants to change the land use characterization. And I would just urge you, we're entering into a period where you and we and they are going to be needing to figure out where these lines should be drawn. Somebody made some decisions earlier. I also wasn't involved in it. None of the three of you were. Apparently, planning staff wasn't even. But lines were drawn. On what other on what other basis should you make a decision to approve a comprehensive amendment, land use amendment? I think you stick with your lines. We're just about to start a big process where you all and we all can say, this makes sense for farmland and this makes sense for development. So anyway, let me see if there's anything. Split it. Yep, no, let's work together on the upcoming changes to the comprehensive plan. Thank you.
little stiff here. I just got back from the Amazon jungle. Anyway, my name is Cynthia Muse, and I am here to speak against the Underwood project. May I quote Tom Vilsack first? Though the Agriculture Secretary, at the foundation of our economy and our value system is American agriculture. He told growers January 22nd at the American Farm Bureau Federation's annual convention in Salt Lake City, Utah. Vilsack's speech was at once somber and optimistic as he described the steep national decline in farm numbers and acres of what the USDA is doing and what the USDA is doing to reverse that trend. And this was in the Capitol Press just last week. Anyway, I was one of the originals of the Columbia Basin Project, and I can tell you right now that that project was not built on diamond backs. That Columbia Basin Project, as we know it, especially Block 1, was built on the backs of children and families who sacrificed and worked hard and gave everything to make it work. And it was migrant labor did not come in until 20 years later. And so the whole reason for agriculture and for this to all exist as commercial and industrial and productive agriculture was because people gave it all to make it work and keep it to last. And Block 1 was the first. It was the original. It was the project that was put forth by the Bureau of Reclamation to prove that this greater Columbia Basin would work. And it certainly isn't the Yakima Valley, nor is it the Spokane Valley. They're not even close in comparison. This was one of the finest Bureau of Reclamation projects ever put together, and Block 1 was a lead on it. So I ask you to consider that those of us that are still living in Block 1, which we do, and I'm certainly not protecting my own land, it's in Block 15 and 16, but that we ask to give consideration for those that still have the right to farm, those that still have hobby farms, which we love. It's really cute to see 5 and 2.5 acres or even 1 acre. How dare you say that those aren't productive parcels of land? Of course they are. You ask any 2.5 acre person with a couple of chickens and horses and things, and they consider themselves agriculture, and they have the right to free and open space. Those that have the right to continue to farm in Block 1 like they always have, their right to farm. And also the whole Columbia Basin project was laid out on the most beautiful of grids for everything from roads to utilities to property lines to, if there's ever a question, you resort back to those grid networks that were based on townships and section lines and things. And I'd say in this case, we're real close to some boundary lines that are based on what? Sections and townships and things where we need to consider that those properties fall within or without of those boundaries. And like Marla says, where do you draw the line? And I ask you to really consider those that are already there living now that would really appreciate having this kept rural, and leave urban sprawl and urban boundary growth where it belongs. Thank you.
Anyone else for public comment?
I'd love to speak for public comment, but originally the Department of Commerce individual was going to make a presentation not related to
That would be appropriate.
official duties, and I'd like to hear him speak first before I.
So the staff's portion of this is complete, is that correct?
Correct.
Unless you have questions later on or something, or you want us to address something. We're not presenting anything else at this point.
Okay, I just wanted to understand that there wasn't going to be a rebuttal of positive or negative comments, correct?
We don't do that generally.
Okay, I just wanted you to
We
steer
just
here,
try
so I was trying to
clarify.
understand.
Thank you, Mr. Chairman and Commissioners. My name is Steve Davenport. I'm a senior planner with the Department of Commerce. I've been a planner for over 25 years. I led the planning effort in Spokane for most of that time, so I'm very familiar with these hearings. I've been to a few of them. I did submit our letter for the record.
Can you speak closer to the
Speak closer.
microphone,
Okay,
please?
very good.
Thank you.
Thank you. I did submit our letter for the record. So I'm not going to kind of go through that detail by detail. I'll try to make my comments brief. I'd first like to talk about the LAMRIDs, the limited areas of more intense rural development. And I think a little background is helpful to understand what the purpose of a LAMRID is. So when the state legislature started doing their work to adopt the growth management plan, one of the main goals was to stop sprawling development. Sprawl was one of the main concerns. And so they addressed that by doing urban growth area boundaries around cities and urban areas. And everything inside of that is urban. Everything outside was intended to be rural. But one of the questions they ran into was, we have these, in these rural areas, we have these small crossroads developments. Our small communities are not big enough to be incorporated into towns or cities. So those areas, they needed to be recognized because the rural development standards would not apply it to those small communities. I mean, you couldn't require 330 feet of frontage in those little communities. So they needed to be recognized so they could have their own development standards. But the legislature didn't want those areas to expand. So, so that's where that concept of LAMRIDs came in. And there's basically two requirements to designate a LAMRID. One is you have to identify the area, and it has to be an area that's built, that has buildings on it, infrastructure. And it has to be built before 1995, and that's when Franklin County was mandated into the growth management plan. So it has to be built before 1995. Vacant, there was no intention that these would be used for vacant property. So the two requirements had to be built. And then the other one was there had to be a logical outer boundary. So the boundary, you would take that development and draw a tight line around it. And that would be the boundary. And those boundaries were never anticipated to grow. It was just to be keep it in its present state. You know, whether you agree with that or not, that's what the LAMRID is for. So these two proposals, they both include vacant land, so they don't meet the first requirement. And you can't really put a logical outer boundary around vacant land. So in terms of the LAMRIDs, our position is they are not consistent with the Growth Management Act. So,
Excuse me, is this for public comment, or are you making a presentation here?
this is public comment.
And do we limit public comment? Okay, continue.
Okay, and on the agricultural land of long-term significance, there is a requirement that you can only do those in a comprehensive manner. And I'll just read from WAC 365-190, 04010C. And that says, in classifying, designating, and de-designating natural resource lands, counties must conduct a comprehensive countywide analysis. And that's very clear within the statute. That section also states that site-specific proposals to de-designate natural resource lands must be deferred until a comprehensive countywide analysis is conducted. And that's WAC 365-190-040 10B II. Also, in your own comprehensive plan, you discuss de-designation of agricultural lands of long-term commercial significance. And I'll just read that. It says, to dedesignate, dedesignation may only be used during a county or area-wide process and not on a parcel-by-parcel basis. The county should consider requests for designation only in connection with urban growth area expansion requests and during periodic updates of the comprehensive plan. So in conclusion on that, in order to justify removal of the agricultural designation on this parcel, the county should conduct a countywide study of their resource lands and demonstrate that the parcel no longer meets the criteria to be designated as agriculture of long-term significance. And there was a statement that Commerce has threatened to sue. I've been in all those meetings. There was never a threat that the Department of Commerce was going to sue about this matter. So I just wanted to make that clear. There have been no threats in that way. So the Department of Commerce recommends denial of both of these proposals. Thank you.
Mr. Chairman, is it appropriate for any questions at this time of public comment, or no?
Do you have any questions for him? Or?
I do kind of have a specific question. So my question is, you said a LAMIRD only applied to something that was done pre-1995. So based on that, no development in any form or fashion should happen post-1995 based on that statement. Is that relatively accurate?
It's not rural in nature.
And so what would be that?
That would be 5 to 10 acre. Generally, 5 to 10 acre lots are larger.
So it would be the position of the Department of Commerce that no development would happen in Franklin County that is smaller than 5 acre parcels.
If you're outside of an urban growth area boundary.
Okay, so any rural area outside of the UGA of the city of Pasco or our other cities in Franklin County, so none of them would be appropriate for anything smaller than 5 acres.
Well, when I say 5 acres, that's a general term, and the courts have said that local circumstances can drive that, but in general, most of these decisions, if it's less than 5 acres, it's not considered to be rural.
Thank you. And then in regards to LAMIRDs, so a LAMIRD is only anything that happened pre-1995. So any of the, this map we have here on the wall, so this right here is under construction today to be a smaller than 5 acre parcels. So by definition, that would not be a LAMIRD, nor would this site itself would not be a LAMIRD, because it does not fit inside of that designation at all, or even close to.
So that was probably adopted in the past, and I don't know if that was adopted pre-GMA or post-GMA, but Commerce has no authority to either approve or deny these projects. We do not have that authority. So it could have been in the past that was adopted, and if it's not appealed, then it would stand. It would stand. So that could have been something that happened. So it could have been either one of those.
So all of the development that has happened since 1995, post-1995 in Franklin County, by definition, the Department of Commerce would have been or is opposed to any of those actions.
I'm not sure what actions you're talking about.
In any rural development that is less than 5 acres. The action that is, there's active construction happening on this, so the Department of Commerce is opposed to that.
We would definitely be concerned if that's considered urban development, then it's not supposed to.
Thank you.
But the courts have left some leeway there, so.
Thank you.
Just so you know that. Thank you.
May I provide a clarification regarding LAMIRDs as well?
I'd like to any further public comment would be my opinion.
Yeah.
Hello, my name is Robert Carcino. I live at 130 Terrace Drive, Franklin County, Washington. I take a little bit of umbrage at the suggestion of the paid representative for the Underwoods, who suggested that those who are opposed to this live miles away from the locus of the proposals. I live close to Fanning Drive. I'm outside of the urban growth boundaries, and so I am, according to the interpretation given by the Council for Underwoods, which says their property is within 1.5 miles of the urban growth boundaries, I by definition have to be even closer to the Underwood property. So I'm not several miles away from the property. I come from a farming family in the South Seattle area originally, and I understand the precious nature of farmlands. I lived through seeing all of the Duwamish Valley and the Kent valleys converted into urban sprawl, and all the beautiful farmland that was in there was lost, except for the couple of acres that my grandparents kept, and which we ultimately sold to the King County and City of Tukwila to develop a suburban park and a fish enhancement project. So I know what happens when property is converted to other uses in kind of a mishmash area. You have, under your rules and regulations, a process you're supposed to follow when you're making decisions of this sort. You do not make them on an ad hoc basis. I fully support the original position of the Franklin County Planning Department, who are the experts in your county, and your legal counsel, Mr. Briggs, who's your expert legal advisor. I expect to hear from a paid representative of a landowner an alternative set of rationales and interpretations, but that doesn't make them right. And I hope this county relies upon its experts and not upon people who come in from another county and suggest to us that this is the way it should be done or looked at. I believe that these should await the next process of amending the comprehensive plan as suggested by the Planning Department. I especially am concerned about the Underwood proposal. In that case, we're talking about prime irrigated farmlands that are all in the designation of Altex. I'm also concerned that it is a spot rezoning, not rezoning, but spot change in land use miles away from the Pasco urban growth boundaries. There has been no demonstration that in fact there was any kind of error in laying out the original Lamoureux in that area. In fact, it follows the section line, and it's a straight line going north and south. There's been no demonstration that there's been an actual change in circumstances that it can't be farmed. Rather, and it immediately abuts more prime farmland going further south for miles. So it just starts a domino effect from a distance, from several miles away. I drove it this morning. It's more than 1.5 miles from the Pasco urban growth boundary. They may have thought that Fanning Road is the urban growth boundary, but it is not. The urban growth boundary for Pasco is much closer to the Dent Road bend, which is another mile further to the south. But what we're talking about here is where, particularly with regard to the Underwood request, there's already 192 acres of land that the Underwoods own that's within the Lamoureux and which they can develop. There's no demonstration of a need to have more land converted from agricultural use to residential use. We just went through a process a couple of years ago of authorizing, agreeing with the city of Pasco to expand the urban growth boundaries of the city to encompass approximately 3,000 acres of residential, now zoned land that was formerly agricultural. So this county has done a tremendous amount to try and make land available for development by approving those urban growth boundary expansions. All that land, according to Underwood's council, is very close to their land. They say 1.5 miles. So, I mean, you've got plenty of land there that you can develop into residential uses. Okay, it's already approved for that purpose. City of Pasco has annexed and rezoned most of that land for residential use. And out at the Underwood situs, you've got the 192 acres that Underwood owns immediately adjacent to it, which they can use for residential development if they so wish. And you have the other 83% of the Lamoureux area of the River Shore Lamoureux area. And all of that can be developed. So there's no shortage of residential property. There's no problem to solve. And by changing the land use designation for this property, you do nothing to make property more inexpensive to develop. Most developers start out with a small portion of their development and they move on up to develop more and more segments. This is nothing new. This just allows one landowner potentially to expand from 192 acres that they already are authorized to develop to over, 230 or so acres. There's no need for this. There's been no demonstration that there's a impairment of its use for agricultural purposes. I'm sure other farmers would be interested in buying it for further agricultural use. I would be interested myself. And you know, to say that only, so that's the underlying basis for why this should be done has not been proven. We have shown, your planning department has shown, the Department of Commerce has shown, your legal counsel has shown that undertaking this action would be a violation of law. And so, you know, if nobody appeals, we skate by. But heck, we're a law-abiding county, right? We're Republicans that believe we should do the right thing. And I just can't see this Board of County Commissioners approving actions that their legal counsel has said are not authorized by law, and their professional planning staff has said are not authorized by law, and there's been no showing of the need to make them, particularly with regard to the Underwood property. And this idea that we can't talk about what the future impacts are of changing land use from agricultural to residential is beyond how I could ever understand it. No one who has been involved in SEPA or NEPA environmental analysis would ever make that kind of assertion, because you need to look at the foreseeable impacts of what is going on now. Once you turn this into residential land use, you've given the initial green light for the process of residential development to occur. And so you have to think about, where are the roads going to be that are going to provide the access? Where's the water going to come from? More importantly, what are the impacts on the rural nature of living out in Franklin County on the people who are law-abiding, living on properties that were developed in accordance with the comprehensive land use plan? It just boggles my mind that there's some suggestion of, well, we have to do this because the applicants have been waiting for a couple of years. No, they have to demonstrate an actual need for why this should be done. We're a proud agricultural county and community. We've given thousands of acres for urban development just a short distance away from these properties. They haven't been developed yet. There's lots of land to already develop that is in a residential use designation. So please don't act contrary to the guidance of your legal counsel and the guidance of your planning department. And I've got to say something else. I would encourage everyone to look at the YouTube videos of the Planning Commission meetings. They make for some interesting viewing and reading. I submitted comments to that process. I couldn't attend because I was out of town. I have no idea if anybody even read my comments on the Planning Commission. I do know that on the videos, one individual, I don't want to state his name, but he actually said, you know, I've got other work to do, and you, the planning department, keep sending me all these documents to read. I don't have time to do this. And the rationale he suggested was, I'm just in favor of any more land being converted to residential because then there's more land that can be used for that purpose, and maybe prices will come down. But changing a land use designation has nothing to do with actually building properties. And the Planning Commission process here is not anything that, if I were you as county commissioners, I would want to rely upon as having done a in-depth analysis. Those folks basically said they don't have the time to do that kind of stuff. They were even in a quandary as to why in the heck was this presented to them. So, and we have the unusual factor of the representative of the engineering company who had made at least one of the requests was on the Planning Commission at that time. And the ultimate recommendation that was submitted to you with the conditions that were included could only have been issued if he participated in the process. In fact, he, to his credit, said, I'd like to stay out of it. But there were only 3 other Planning Commission members present when the ultimate determination and the recommended findings was approved by the Planning Commission. And there was a roll call vote, and Peter Harpster voted yes in favor of the roll call vote. And I see he was here today again proposing this. So it's kind of interesting that the story in the Tri-City Herald just yesterday suggested that there's a concern over appearances of impartiality. And I'm not saying there's anything wrong there, but I do agree there is a question about appearance of impartiality. So we come to you as the ultimate decision maker. They are just making a recommendation. You make the decision. And I hope you'll consider the preservation of farmland in Franklin County and the preservation of the rural nature of living in Franklin County outside the urban areas as something that should be retained. Certainly, your comprehensive land use plan says that. It tells you that areas of Lammerts are not to be expanded except at the time period of the comprehensive land use plan total redevelopment periods. I do have particular concerns about the impacts on traffic, not just for myself and my neighbors, and I speak on behalf of many of my neighbors who couldn't attend, but of the other farmers who live further out north and will have to use the roadways, which are already inadequate and which will become more inadequate as more and more houses are built. And so we ought to limit the more and more houses that are being built to the Lammerts that are available until we have time to do a comprehensive analysis of the land use plan and really figure out what's going to be required to provide police services, roadways, parks for a suburban type development that certain parties are trying to encourage in these areas. This is not the time, this is not the place, and it's illegal. And I hope we don't just undertake illegal actions on the hope that nobody appeals. That would be a sad day for the county of Franklin. Thank you.
Anyone else for public comment? Hearing none, I'm going to close the open meeting.
Mr. Chairman?
Yes.
If I may comment. As a farmer, north Franklin County, I realize that some of the farm ground has been put into the UGA. That 190 some odd acres that the Underwoods are farming has got a pivot on it. And as a farmer with minimum wage where it's at, you can't be farming these little parcels of land and make it economic unless you're into a specialty crop. We're farming circles because it's convenient for the farmer and profitable for the farmer. And I realize this isn't in the UGA, but it's right beside houses that are being built, as Mr. Bauman has pointed out. And as far as Mr. Oberdine's property, he no longer is going to be able to farm that. I know he's a hay farmer, I'm a hay farmer. And when you're out baling hay at 2 and 3 o'clock in the morning, residents are going to get upset. And there's going to be residents all around it. I, for one, I think that this is probably a good challenge to the Growth Management Act that I'm not in favor of. And I'm curious, Mr. Bratton, if we were in one of the counties, the 11 counties that only has to do the minimum for Growth Management Act, would this even be in question?
Actually, and forgive me, I don't pay too much attention to what the ones that aren't in it,
The
but I
11
believe
are the
it
counties
would.
subject to critical areas and natural resource lands requirements only.
Right, so this is an all-tac, that's natural land resources. So as far as the Underwood, whereas Oberdeen, I always say his name wrong. You know, though we haven't heard back from the Growth Management Hearings Board on the compliance change.
We have no representation on.
Well, the courts have ordered, so they have to do this compliance thing. But my point is that it appears that the Franklin Crops, Franklin Soils question has been answered, and those are not all tax. So Mr. Olberdine's property is not an all tax. And that was part of the delay, was because we didn't know Mr. Olberdine's property was in flux because we were waiting for that hearing, and that's really what created the delay. So, I mean, but yeah, if we were in the 11, Mr. Underwood's property would be affected, not necessarily Mr. Olberdine's.
Okay, thank you.
Mr. Chair.
Yes, the chair recognizes Commissioner Bauman.
So I don't remember who it was, but I believe I heard somebody say that Franklin County is in need of between 23 and 2,500 new homes. Is that kind of the number that has been?
Say that's probably correct. I mean, that's, again, it's something that we would be, all of this is coming up, that we start all of this analysis. So all the data we have and things like that is based basically on 1820 numbers. Dynamics have shifted. Staff recognizes that and is aware of it. However, you know, again, our recommendation is based on the regulations in place at the time.
That's a good enough answer. The city of Pasco has stated on numerous occasions the number has ranged from 24,000 and higher of how many homes that they need over the next 20 years. And so, irregardless of the exact number, it's very obvious and evident that we are at a dire point in our housing shortage. We need houses. Could you speak just briefly to the 1,700 notices that went out? that's, I know that there's been conversation in the city of Pasco that maybe that they should grow their radius of notices around an event that happens. Could you speak to how we determine how far do we send the notices?
All landowners within 1 mile, if it's outside of the UGA, due to the fact that both of these properties are outside of the UGA, everybody within 1 mile was notified.
So there's roughly 1,700 homes within a mile radius of this location.
Of these locations.
So
This
it would
is
include both properties.
Correct.
And so it would
So
include
the
the
majority
area
probably came out of that. If you look on, this one doesn't have it, but
directly south of the Olberding property.
you'll see that the city has development, so that circle swept down into there. It also hooked over into the rural shoreline development area where we have and then, of course, the Lammer to everybody there.
Okay, I understand. I appreciate that. I wanted to say something that it kind of made me smile. This is I guess it's one of my lifelong goals or dreams that I want to be a part of, as Mrs. Muse spoke to, is the Columbia Basin Project. I think that it is we're the breadbasket of the United States, the Pacific Northwest. I want to see the project continue to be built. I know there's been some movement happen with our legislature and some. I want to see that continue to happen. As Mr. Didier pointed out, this is no longer prime farm ground. It's got a lot of development happening very close to it, and it is no longer prime farm ground. As somebody that grew up changing hand lines, I changed real irrigation just a little bit. That was kind of when I was very, very young. I did get to do that a little bit, but I changed lots and lots of hand lines, and then I changed lots of wheel lines, and there's a reason that that circles are used today, is because of the efficiency and because of that's what makes it the farm ground so valuable, is you can be efficient with the irrigation of it. This property specifically on the screen is it's got 2 circles on that. Whether you use that circle, in this case, the one to the north there, I would say is roughly 1/3 of a circle. Whether it's doing 1/3 of a circle or a full circle, the cost of that infrastructure is the same. And there's a reason that irregular pieces like this are difficult to farm, whether it's a wheel line or a circle. It's not an efficiency of use, and so it does not appear to be prime farm ground any longer in the way that it's been broke up. You got a canal on 2 sides, a road on 2 sides, and residents on another side, and all of the residential that's in that area doesn't show that. I appreciated the clarity that we received from the Department of Commerce indicating that a Lammert is a pre-1995 development, and that really helped in my understanding with the applicant, and they're saying that this is not Lammerts in either case. I appreciated that clarity there, and Mr. Chairman, I'd like to make a motion that ordinance number 02-2024, option B, be voted on and approved.
For clarification, option B is?
The Olberding property with all of its accompanying information.
I second.
Hearing a motion and a second. Any discussion? All in favor, say aye.
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 Aye. Motion passes.
Mr. Chairman, I would like to make a motion that we approve option C of ordinance 02-2024 in relationship to Diamondback Farms with all of its accompanying information.
I'll second.
Have a motion and a second. Discussion? Hearing none. All in favor, say aye.
Aye.
Aye. Motion passes. Moving on to
Thank you.
presentation by, thank you, Michael Namchek, radio microwave upgrade presentation. We're going to take a 5-minute recess, if that's all right. Thank you.
Thank you.
to the presentation presented by Michael how do you pronounce your name?
Namchek.
Namchek, thank you. Welcome.
Thank you. I was going to say good morning.
Good afternoon.
That's
all
say
passed.
good afternoon.
That's all passed.
Sheriff, if you don't mind, I'd like to introduce Tom Huntington, who's a part of the Richland Fire Department as a chief, and he's been pretty vital in this process, and Michael, who's put this together along with Liz, and this really important subject. But I wanted to thank Tom personally for all his work with this and being here today and sticking around, so thank you.
Thank you.
Okay.
You're up.
So Mr. Gonzalez asked me to put together a little presentation that kind of explains how Franklin County's public safety communications system works and where we're at today and where we're going. Tom is here to assist in the latter half of that because well, you'll see as we go here. So the Franklin County Public Safety Communications System is really two parts, the microwave piece of that and then the radio piece of that. So the microwave piece of that is like a freeway system. And all of the roads lead back to dispatch center, to the dispatch center or CCOM, and then from CCOM out to the first responders. The first responders are the radio traffic. That's the information that rides across the freeway system or the microwave. So when I say the Franklin County communication system, that used to be true. It used to be Franklin County had a microwave system, Franklin County had a radio system. In today's world, that's not really true. Today, the systems are joined with the Benton County system. We are one system. We still operate disparately, but in reality, if they have a problem, we're going to have that problem. If we have a problem, they're going to experience the same problems. And as you can see, the microwave system is not one piece of gear at one location, and the same with the radio system. And if you just focus on the Franklin County side, the Benton County side is just up there to demonstrate that we have the same situation on both sides and we're tied together. A lot of these sites are co-located together, in fact. But we have 6 locations that have microwave sites on them, and I've listed them out. When I say simulcast radio site, I'll get into what simulcast radio is, but that's our primary repeater sites. That's what law enforcement, fire, ambulance, what they all talk on, including our public works departments and even our jail. So this is kind of a geographical display that we put out there because there's a misconception that the microwave is a really simple thing. Somebody can be easily upgraded, but our coverage area basically is from right about here along the river right here into Walla Walla County, and then the rest of the space on the map is what we have to cover geographically for law enforcement and fire for our Franklin County / Benton County public safety system. Just real quick, a brief look back. The Benton County system was built, and these numbers, these years are approximate. It may be plus or minus a few months, might move into the next year, but this is just a basic look at where we came from and where we're going to. In 1992, Washington State Emergency Management, under a grant from the CSEP program, which was the Chemical Stockpile Emergency Preparedness Program, built a microwave system and a radio system to support that program, and it was primarily in Benton County, which is what they use today. That is their communication system. In 2000, roughly 2000, Franklin County began building a new communication system. They were just short of strings and cans out there, guys. There wasn't a lot of infrastructure in place. In 2005, we put in the first microwave system from the courthouse to Jump Off Joe and actually linked our dispatch center, our 911 center, to an actual communications system. In 2006, we began working on making a system that was similar to what Benton County had in Franklin County, where we could cover the entire county with radio. This equipment was all purchased from eBay and anybody I could find where the equipment was available to build this system. In 2010, the Department of Energy notified us that we had to get off of Rattlesnake Mountain. And I made proposals, and we moved at consolidating all of the many facilities, 23 of them that were on Rattlesnake Mountain, into a single public safety facility. And at the same time, that's when Franklin County's simulcast system was completed, at the same time as that consolidation on Rattlesnake Mountain.
So you had to get off of Rattlesnake. Where did you put this?
So we made a proposal, I made a proposal to DOE to consolidate into one facility on Rattlesnake Mountain.
Good, because
They told us to get off, and it just wasn't feasible, it wasn't realistic.
because a lot of this communication is line of sight, correct?
Correct.
So the higher the better. Okay.
Yes, sir, to a degree.
Okay.
Okay. So in 2010, we completed the Franklin County simulcast system, knowing that all of this equipment that we've been purchasing needed a plan to be upgraded and to continue processing. All we're doing is establishing the system. It still needs to be upgraded and continue to move forward. We needed to have a plan for that. So in 2015, Pasco PD decided they no longer could handle the issues with the VHF system, and the VHF system is what we call our communications, our radio system. It's really a frequency, but that's what Franklin County uses. So they joined the Benton County 800 megahertz system, which was the one that I was speaking to earlier that was built by the CSEP program, or Washington State Emergency Management. In 2017-18 timeframe, we merged the two PSAPs together. The PSAP is the 911 center. We closed Franklin counties down and moved them into CCOM, Southeast Communications, in Benton County. That merger is what really made our communication systems one system. Because we share the channels, and honestly, we share the systems. The VHF system and the 800 system, while our field units are all VHF radio, they are tied together via the dispatch center to work together as a single system. They have the same channels on both. In 2019, we're at a critical state. Our equipment is old and obsolete, which I'm going to speak to in just a second, but we're having difficulties keeping the system alive. Okay, so real quick, I want to give you how the radio system works based on the microwave and the radio system that we have today. So I'm going to do that by demonstrating what a voted simulcast system is, which is the systems that we are using today. So we're going to do that with a scenario. So we have an incident out there, in this case a car accident. Law enforcement comes and needs to make a call, needs to talk to the dispatch center. They send out the call. Every mountaintop that can hear that call receives it and then sends that back to the dispatch center to what's called a voter. That voter listens to each one of those individual audio tracks, makes a decision on which one is the best and clearest signal, and then sends that to dispatch. Dispatch then makes their decisions on whatever the incident requires and sends that out. That goes to every single site and is sitting at each of those sites. Now, this happens very fast, but it is sitting at each of those sites before it's transmitted. Once it's all received, then the timing equipment sends it out and the officer gets his information that he needs and the call proceeds. And that's what makes it simulcast, because everything happens at one time. All of that equipment is extremely expensive, and it's getting harder and harder to find that equipment. Okay, so I've been talking about VHF and 800. So VHF is a frequency. 800 is a frequency. The real difference is in the technology that those frequencies are utilizing. So in our current system, it is an analog system. It takes the signal from the air, it processes it at the sites, and then sends that information via the microwave around back to the dispatch center, where then it's decided and processed. The 800 system is a digital audio processing system. It allows for a lot more features and like their AVL locations and many of the other features that the fire and law enforcement community use or would like to use on a regular basis that aren't available in an analog VHF system. Also, the frequency spectrum. So in the VHF system that we have today, we have 22 channels, 22 sets of frequencies, or 44 frequencies that are utilized. Each one of those frequencies dedicated. So if you have, and I've listed them out here just so that they're generic, Law 1, Law 2, Law 3, and so forth and so on. So Law 1 is used by, let's say, Connell PD. That's the only thing that channel is used for. So it ties up those two frequencies, and they're locked. Now, you know about the traffic from Connell. There's not a lot of radio traffic from there, but those two frequencies are sitting there unused 90% of the time. When they're used, I mean, you want them there, but a lot of times they're not. In an 800 megahertz, or in the trunk system, or the 800 system that we have in Benton County, the system has, in the current system, there's 10 channels total. One channel is dedicated full-time. That's a control channel. That's where the subscriber units or the radios that are out in the field are talking to the system to let them know that they're there. The rest of the channels are available, so you could have thousands of different channels in there, and it's whatever's being used, it goes to the next available channel. So if Connell wants to talk, they key up, and if channel 1 is open, boom, they go out in channel 1. If channel 1 is busy, then it drops to the next channel, channel 2. The magic is done in the digital over the control channel, where it's telling the subscriber who wants to talk, it tells them who he wants to talk to, and those radios activate on that same channel. So it really shrinks up the frequency spectrum and makes the management of those frequencies and licenses, and frankly, the cost of equipment on the mountaintops much cheaper. Okay, so as I said, we have 22 channels, and that's repeated channels up on the mountaintops that make up the Benton and Franklin system. That's 44 frequencies. The licensing, I can't even tell you. We have over 60 licenses just to maintain those frequencies. There's also additional radio-to-radio channels. Those require additional licensing. So currently today, all of Benton County law enforcement is on the 800 system, and all of the Benton, or all fire in Benton and Franklin County are on the VHF system. And in Franklin County, there's a multiple. All law enforcement here has the ability to operate on the 800 system, and our sheriff and places up north, like Connell, have the ability to operate on on VHF and 800. However, it's very cumbersome if they're out on a call to switch between the two systems, because as I was telling you, that control channel that has to affiliate the radio, yes, sir.
So it's the same radio, but it's the patchwork back at the central point.
Well, I'm getting to that point. Right now, I'm talking about within the same radio, they have, it's called a dual band radio. They have both bands that they can operate, but they have to de-affiliate from the 800 system, which is what their preferred method is, and then talk on the VHF system if they want to speak to fire. And then they have to go back to the another spot on the radio to re-affiliate to speak to law enforcement. So it's very difficult for them to talk back and forth in that method. It is possible, and it is something I recommend that they contain that or maintain that for interoperability outside. But right now, we have the dispatch center who puts a patch in. What this patch does is it crosses those channels together. Now, it is not something reliable for super long-term use, but it is how we're getting things done today.
To last at least until 2030, correct?
I pray.
I'm trying to lighten us up in here just a little bit.
Yeah, that.
He already answered that question, but not here today yet.
Yes. We're getting to that, but no, it won't. It will not. Okay, so besides law and fire, we also have to work with all of our surrounding agencies. Now, this is a fire map. which I hope I don't offend any of the law enforcement here, but I didn't have every specific agency in this time frame. But this basically demonstrates all of the surrounding area that we have to interoperate with, besides just our county and Benton County's agencies, all of the surrounding agents in Adams County, and Grant County, and Klickitat County, Oregon to the south, and then all of the different Walla Walla County fire agencies, as well as Whitman up there is on top of that. And on top of these, we also have state and federal agencies that come in that we have to be able to communicate with on incidents. So it is a huge, huge undertaking to get all of this done. We're being successful at it today, but our equipment is obsolete. The technology that we're using to accomplish this is dated in Franklin County. Spare parts, almost non-existent. I can't even find parts on eBay to replace stuff that breaks. We are doing everything we can, and I feel like we're doing a really good job at keeping the systems alive, but we are coming to the end of the road, gentlemen. It's not going to be a joke. We have one vendor that will repair parts of our microwave system if they have the spares, or if they have those parts on hand. Our failure rate is increasing. These are going down more and more often, and it's getting more and more difficult to repair them. Our supporting equipment, I don't want to go into what they are specifically. I'll show you a quick slide here in a second that explains them, but basically it's the audio processing equipment and the transport stuff that helps the microwave get the signals on and off. It's obsolete, it's out of date. We're having the same problems with it as we are with the primary equipment. The remaining life on the equipment, I can't tell you. We're running out of parts and pieces, and people who will support it, and folks like me that even know how to operate it. I'm old, so is the equipment.
Is there any value in selling it on eBay?
We might make a fortune if we can find one other place that has it.
We just don't want to be the last. We don't want to be the last.
Don't want to be the
one.
last.
Well, it's funny you say that. This right here is a repeater. It's called is made by a company, Harris. It is a Master 3. It is the piece of gear that repeats the signal out and does the actual RF, the radio on the mountaintops. This was end of life in 2017. Franklin County purchased the very last one of these ever produced and put it in as a new site. We replaced this equipment we have started replacing this equipment because of failures. We can't afford to replace everything. So we bought a used system from Walla Walla, TB8100s. These radios are the same as what you're looking at with the Master 3s. These are end of life, 2018. This is all from one of our sites in Connell, Washington. This is the channel bank. This is still produced. Good news, still produced. To bring this up to date to current standards would be $30,000 to $60,000 per unit, depending on the site. So the new equipment operates on IP backbone. In order to make it work with our existing microwave system, we have these little boxes, and they're called RAD Ethernet converters. It takes the Ethernet signal and turns it into a T1. T1 is what our microwave uses to transport the signals around. It was end of life in 2015. I recently had to find one. I could not find this exact model. It cost $8,000 for a four-port unit, and it barely functions. The technology is out of date, and people are just not building them. And the ones that are, it's not quality, and it's a struggle. That brings us to the microwave system. Both the channel bank and this T1 converter put the signals onto the microwave, which is this Constellation radio. End of life, 2015. This right here is called a loop switch. At each of our sites, as you can see in the previous photo, there's two microwaves. One goes in each direction. That is, it was put there to help keep us alive in the event of an incident where we lose a microwave. So the microwave can recover with this switch and send it the other direction if one of them fails. This was end of life in 2004 and is no longer produced or supported. So Benton County has been working on an upgrade or a path to upgrade their system. And at the same time, they've included Franklin County system because, as I said, we are one system in reality. And they've come up with a way to do that. They've got some proposals in place. The total upgrade cost for just the microwave is $6,532,509.12. They were able to secure a federal grant for $2 million, which brought the price down by $2 million. And if we can agree to interlocal agreement, they have a way, the Benton County Emergency Management Board,
Emergency Services Board.
Emergency Services Board has agreed to fund that as long as they have a way to get their funds back. So there's an ILA that's being circulated around that has some amendments that need to be taken care of.
Our portion would be due when?
So our portion as far as Franklin County, or as far as Franklin County, would be roughly $1 million, $900,000 of the microwave piece only. Okay.
And that portion would be due, if they were to fund it and we were to repay, when would that repayment be due?
So I don't want to speak to that because I don't know all the details, and I will defer that to Tom.
I believe, if I have this correct, and Mr. Gonzalez may be able to clarify as well, the Franklin County portion of this would be in 2025, towards the end of the microwave upgrade project. Does that sound right?
That sounds correct. And I know Jeff Briggs has been working on the contract, and I think the biggest thing that stuck out to us is the ask for all jurisdictions to share in the cost equally. I know in some of the earlier meetings, Benton County kind of pushed back a little bit, but I don't know if that's shifted. I haven't heard any recent pushback in terms of having equal ownership, but it sounds like there's positives in equal ownership because then you don't feel like you don't have as much a stake in the game. So in my perspective, it's a good thing. It's always a money issue because it's quite a cost, but obviously this is a necessity that we can't avoid. The thing I would like to know a little bit more about is can you explain kind of the Motorola piece and how they're involved in the equation?
Yeah, I can speak probably in layman's terms.
Yeah.
And if there are specific questions that we can't answer today, I'd be very happy to get a written response back to the commissioners as well. As I understand it, on the microwave portion of the project, Motorola is serving as sort of a project management facilitation, and we may end up with a different vendor's equipment in the microwave infrastructure. But Motorola has the engineering expertise and the working knowledge of our system based on the current system that we're in with them.
Thanks.
I did have a quick question. So I have taken a look at the various ILAs. I think there's one, and then there's a financing document. It's a little bit confusing in terms of what project would be financed. Would this be a specific microwave, or is it going to be all the microwave systems by county-wide?
So the ILA that is being put out is to address the capital funding of the bi-county microwave system, or what would be considered the bi-county microwave system. So the sites would still be the same, everything would be the same locations, the county would still have the same responsibilities as far as the sites are concerned. The microwave itself would now fall under CCOM they're using their equipment, SUA.
Service upgrade agreement.
Service upgrade agreement. And what they've done is they've said, hey, can we add this equipment into the upgrade, which then forces the issue to the board to get their equipment upgraded, because they're in the exact same position that we are with their equipment. And they have included the Franklin County because, as I said before, these two systems are one system essentially.
Is it fair to say that if we were to go this alone, that our price may not be 6.5 million, but it's certainly not going to be a million if it's a standalone system.
Yes, sir, that is absolutely correct.
So there's a immense amount of motivation to work well with a partnership here, and we would have access to a much larger system if we do it in partnership.
Agreed, yes.
And has any of the 5 or any of the other 4, is any of them agreed to do this, or are we all in the same stage of considering this?
I think we're all in the considering stage, but moving quickly towards needing to make a decision. If you can, the date of 3/31/24 is the point at which we need to execute or risk losing the $2 million in federal appropriations.
And also the Motorola proposal expires on March 31st.
Yes, you're right.
And when that expires, they've indicated that there could be as much as a 30% increase in this cost.
And is there, so that's a $2 million federal grant. Have we attempted to get any state grants or any grants of any other way? And is there any hope for other grants?
Yeah, we actually have done a joint effort across the entire region, Mid-Columbia region here, with our legislators and lobbyists to prioritize the microwave as our first ask in the progression of these 2 projects. So I haven't heard anything back definitively about funding, but I know the cities and counties have been working hard to try and make that happen.
So we have a brand new representative in our, representing us in helping with this kind of thing. So Jason, I would really encourage you to work with these guys and try to do everything that we can to help with that potential grant,
Commissioner, that is something that Water Street is aware of and working on with our delegates out there, so they
Thank
definitely
you.
are aware.
So questions I have.
Yes, sir.
This is system upgrades. Are all of our radios going to be able to be compatible with this system upgrade?
Okay, so remember when I talked about freeways and the traffic? This is the freeway. Brings me to my next slide.
Uh-oh.
Hold on.
Yeah.
So at this time, we do not have a definitive cost on the radio system upgrade. However, as a community, we have been working very diligently since 2016. In 2019, we started to engage a company called Federal Engineering to help us come up with a plan and the type of system that we were going to need. And Chief Huntington has led the way and been the project lead on that. So I want to hand the rest of this over to him. These are the numbers from FE.
So if you remember a few slides ago, there was a side-by-side of the VHF and the 800. Our original plan back in 2016, and actually the proposal to all of the stakeholders, was to just simply upgrade the VHF system. That project currently sits in a $6 to $8 million range in comparison to some much larger draft numbers here. The feedback we got from Federal Engineering, and they're really the expert in the industry on this kind of project, is that we would be back having this conversation in 5 to 7 years because really that infrastructure is at end of life and that technology is at end of life. So we really felt like that sunk cost was a really poor investment across this whole region. We'd spend $6 to $8 million and then spend the same $6 to $8 million doing exactly what we're proposing, and that is to move to the 800 system as a region. The benefit, obviously, is that law and fire and EMS and hospital districts and public works are all on a single public safety platform. These numbers are extraordinarily intimidating. Not even the ballpark were we imagining that they would come at this. But please keep in mind that this would be comparable to like full list retail price on every aspect of this project. We're expecting to anticipating at least to be able to drop about $10 million off of that when the pencils get sharpened and we put the pressure on the vendors and the due diligence that will come with the final form of the proposal. But it's still a big ask. It's still a big number. We recognize that. In terms of my role in this, there are I've lost track off the top of my head, I apologize, but there are over 20 primary stakeholder agencies involved in the transition of the fire and EMS radio system, the VHF system, and then another half dozen sort of peripheral stakeholders. So there's a lot of agencies that have a very high vested interest, a lot of history and emotion, and so part of my engagement here is communicating the path forward and the effort that we'll make. but trying to get all 19, 20-plus agencies in a coherent path forward towards the 800 system. We will be, to your question on the other aspect of this, we have already begun the submission process for federal grant funding. We expect to prioritize this project in the 25 legislative session at the state level and push on Olympia pretty hard to provide us financial resources to make this happen. The other benefit of moving to the digital system is that it meets all the current public safety radio standards and should be a much easier grant ask for all kinds of different venues to find outside funding. So I know we're looking at some very big numbers here, but my primary objective is to bring the actual out-of-pocket cost down for all 20-plus agencies to something far, far more reasonable than that. The contrasting pressure point is that the clock is ticking, and I hear from the technical team on both sides of the river that time is not on our side. So your question about Motorola and the role there and what is funded or that kind of thing through Motorola and the ILA, in all reality, with agreement to move to paying for the microwave project out of pocket, it is possible that we would have to work with Motorola or another provider to do some short-term financing, 5 to 7 year financing, and pay that debt back in order to have a system up and operating before the current system collapses. Lots and lots of variables still in front of us, and we're on the front edge of pulling all that together with federal engineering. And in the next month to no more than 2 months, we'll have a much better idea of both actual cost, the timing and sequencing of those things, and how to prioritize the transition and the funding of all that.
So if I may, can we go back to the map of the surrounding area? When you were talking about well, right there, you already went by it. Are we talking this whole map, we're all going to be on 800?
No, the 800 system will be Benton County, Franklin County, and the westernmost portion of Walla Walla County.
What if, I know time is short, but are any of those other areas on the 800?
Okay, so remember, 800 is a frequency.
Yes.
They are not on the current 800 system. However, these agencies in this area down here, these are on a 450 system of the same technology. And the interface, we have a site right here, right here. That site we're co-located. So tying the systems together is not a huge effort, and CECOM has been in talks with them about doing just that in some instances. There are several state agencies who are already intertied, State Patrol being one of them, and there are others. I was hoping that the Emergency Management Director was going to be here, BCES manager was going to be here, but he couldn't make it today.
So that 450 frequency,
yes,
is that going to be outdated pretty soon too?
No. So it's not the frequency that's outdated. It's the technology that's just the frequency that they're using.
What's the age of the 450?
I'm sorry?
What's the age of it? How long has it been running?
Actually, it's only about 4 years old. They just did an upgrade in there.
It's a newer type of.
Yes, yes. It's very similar. So Benton County, while I told you that we started building that and we built that system in 1992, they're on the SUA, the system upgrade agreement. So anytime that system needs to be upgraded, it is. That's what the subscriber fees and all of that they charge over there are for, is to keep that system at current level. And the 800 system was just recently brought up to its current right now.
Okay.
Its life will be roughly what? This new system we're talking about, if we were to bring that online and it was fully operational in 2026, it'll have a 20-year shelf life?
How about if I say so they tell us 10 years is what the manufacturers. If we do what Franklin County has done always, which I beg of you not to do, but if we continue to do that, I would say we can get, 20 years out of it, 15 to 20.
So the technology will have a lifespan of 10 to 20 years?
Yes. I believe the technology itself will have a much longer span, but you have to keep up with it, especially in the IT world where we're at. A computer doesn't last for 10 to 20 years.
Yeah, nobody still has an iPhone 1.
Exactly, exactly.
So would you go forward? Go ahead.
No, go ahead.
Would you go forward to where you were at in the slides? So primarily Franklin County, the system infrastructure, that comprises approximately how many agencies? So that's Franklin County Fire, 1, 2, 3,
So
4.
that's five fire districts.
Okay.
Connell Police Department,
EMT.
Franklin County Sheriff's Department, the
Hospital
Hospital District number 1. If the second hospital district or comes back into Colotus, it will include them. Franklin County 3, their ambulance service as well. Franklin County Public Works, Franklin County Jail, the
So
corrections.
we're a dozen agencies inside of that 8.8 number.
Yes.
Okay, and then that number on this screen, go back one screen.
Okay.
That does not include that number.
Correct. That is correct. That
Okay,
is
so
correct.
this number right here improves our microwave system, and then if you go to the next page, this is the radio system.
That is correct.
We need both of those.
Yes, sir.
So this number has now risen. So the players, here, the agencies would, for the previous slide, would be roughly the same people.
Yes.
So this number here could equal roughly $10 million, and that needs to be shared by roughly a dozen agencies in Franklin County.
That's
Not exactly, but kind of
Yeah.
in general terms.
I would frame that as worst case scenario. One of the things that we're trying to be really intentional about, and it will come down to our legislative bodies and our executive board on whether they agree with us. But we as the project team and the end users, that is the police chiefs and fire chiefs and so forth. This really is a single system, and we see the investment, although the infrastructure is most needed in Franklin County because the Benton County infrastructure has been built out, it is a single system, and we are all served well by a robust single system. So we're not framing the proposal, and we're not framing the project funding, and we're not framing the conversation around Franklin County is going to have to come up with $8 million to make this work. The owners of the 800 system, which would ultimately be the 5 agencies, 3 cities, 2 counties, the owners will have to come up with that jointly to invest in their system that covers 2 counties, is how we would prefer to frame it.
So for our needs, these two numbers here should be joined together, because we could do this, and it's no good without this.
Correct.
So if we do that and we talk about the microwave system on the previous slide, our number is between $18 and $20 million that we need to have in place, in your opinion, in approximately when?
I would say we're looking at the significant risk of failure on current system in the next 2 to 3 years.
I don't think we can, okay, so right now, where our system is, if we have a microwave failure, you lose a geographical area. So, in other words, if the microwave system in Connell fails and I cannot put it back together, you are not talking excuse me, did I say Connell? I meant Colotus. In the Colotus area, you are not talking in Colotus. Law enforcement, they can get away from that. They've got other means to deal with that kind of an outage. Fire does not. If you have to fight a fire and Colotus is burning down for the 3rd time since I've worked here, it's going to burn down. They cannot communicate together without that system.
So
Go ahead.
So I got a very rookie question for you, and so you're welcome to laugh at me.
No.
So with the technology that has come with Starlink and its satellite-based infrastructure and so forth, can you speak to that in relationship to this? If we were to go I know that it's revolutionized shipping, out on the open ocean that's, far, far from anything. I know it's revolutionized that. It's revolutionized remote places for internet access. Is that something that's ever been considered? Is that even a viable option, or?
Yes, it definitely has been considered. I believe that is the next technology. Right now, we're in kind of a transition stage. Everybody is talking about using cellular and LTE. I do not believe cellular and LTE is the way to go, because we're going to be in the same boat that we are right now with transitioning from the technologies from VHF to 800, where that technology is on its way out. It is at its end of life. And while you'll say cellular is brand new, it's just starting. That's true. It isn't long in the tooth. However, satellite has come so advanced that I believe that within 7 years, roughly, we are going to be looking at systems that are satellite-based, and I think that will be the next big system.
And we're not ready to move to that on a large scale yet.
They're not building the equipment that our fire and law enforcement agencies would need. Correct.
We're just a little early to be even bleeding edge on that, I think. Yeah, but I would agree. I think that's the next iteration of the overall technology.
Well, like we talked, if you can keep this alive until 2030, then, you know.
That's a big ask.
Maybe another way to think about the $8.8 million there is that is a very, infrastructure-wise, that's very comparable to what we would have had to spend on the just a simple VHF upgrade, right? The option that federal engineering said is not a good option for you guys. So that 8.8 million, give or take a little bit, to do a simple system upgrade, that cost would have been borne across the entire system in both counties, right? So again, it is going to be Franklin County infrastructure that needs to be added, because that's where the gap in the current 800 system is. But we would really, as the police and fire chiefs, the SAT for the BCS board, and the project team, we would really like to frame this as a system investment and not just a burden for Franklin County to get figured out in the next 3 years, and how to come up with a lot of millions of dollars there, if that helps from a perspective standpoint.
It looks like we're going to spend $20 million on something that might last 20 years. It could be very outdated in 5 to 7 years. With the technology, the fastest things are changing.
I think it's always a risk. The digital trunked platform that our 800 system resides in is it's a well-established, overwhelmingly utilized public safety communication platform. So the entire we're proposing moving into what is kind of the industry norm. So that entire industry norm will have to shift, and it will. I think, again, in the next decade, you're going to see a shift to Starlink or satellite communications, but that will be part of an industry shift and a technology platform shift. This move to 800 is going to be stable, the most stable option for us over the medium and long term that we have in terms of options in front of us.
And so, Commissioner, the technology is older that we're talking about going to, but I believe that will be the transition, so we get past that bleeding edge. We're in all the problems. They have the faulty equipment when they start off. You know, they sell you the radios that are supposed to talk to satellites, and they realize they don't have enough power, or they don't meet the needs of the users. The system that's here today, that will bridge that transition as well. I think that we're five to 10 years out before the new technology comes into play, and then we're probably another 5 years out before that's stable. So I think that the 10 to 15 years we get out of it is going to push us into the new technology, and I believe that what we have is stable enough to do that.
I just wanted to add just briefly that these costs here are not part of the current proposal, the previous slide in terms of the microwave, and thank you for clarifying. It wasn't clear to me that was for both counties, so that is certainly helpful on my end. But these costs on the next slide, those aren't part of the agreement yet, and the way that the agreement's structured is that each sort of capital improvement or capital expense would be subject to its own agreement. So if we want to have something similar to what is the cost allocation here, I think now's the time. Because if we agree to this now, it might impact our bargaining position in the future if we want to apportion those costs in the same manner. Certainly nothing in the agreement requires that. So
the thought process on that next slide, the thought process is that this would be structured similarly to the previous slide as far as agreement and have a joint, robust system that we all use together.
Absolutely.
Okay, so this is behind, this isn't as advanced as the contract is on the previous slide.
Correct.
Correct. And so this is, I just want to say, this is broken out. The reason I put it up here this way is there's ever possibility that when they're doing the agreements and stuff, that they take the infrastructure and separate that from the subscriber units or the radios in the field, let's just say. So I wanted to make sure that it was clear that the infrastructure itself is roughly $9 million. And most of that is going to be put in Franklin County. And yet it's going to be picked up, 3/5 of it are across the river in Benton County. So that's a big thing. The second part is the $8 million for the radios. Now, I believe that is an extremely high number. That I don't think that we'll come anywhere near that. I suspect somewhere in the half of that range is where it's really going to come down. But we don't have any of those negotiations. We just got permission to move forward with this as our direction. So now that we have the direction that we're going, now we can engage Motorola and get them to give us what the real numbers are. So I'm hoping that we'll be able to give you much better information as far as this project. My purpose here is to let you know that this is coming. We can't wait. I told you about the microwave. If a radio channel fails, we can shut somebody's radio channel off. We can take one away from fire and reorganize things, and they're just operating with less resources. That can happen a little bit. That'll give us a few spares to get us through for another failure. But that every time we reduce that, we're taking away those resources that they get to use out there in the field. That's what radio means. Microwave is much worse case scenario where we have to take out a regional area, but either way, we're getting to the point where this is critical. I mean, we have to do something.
So this is way out there, but there's lots of threats being thrown around that Russia is going to put off an EMP. If that happens, none of this is going to work, correct?
Correct.
There's
That's
no
correct.
protection against that.
I'm not even, I can't even tell you that our fire engines will, there's like 9 computer systems on every fire engine now.
All of our cars, we've shut down everything.
Yep.
And that threat is being thrown out there more and more.
Yep. I think it's entirely possible in the era that we're entering into.
Okay.
My commitment to you, commissioners, and thank you for letting me join your meeting today, is we are turning over every rock. We're leaning into Olympia. We're going to lean into the feds. We lost our grant writer, and I think we've found a replacement grant writer. So once we have that person on staff, we'll be having her chase down every possible opportunity for outside funding to make this happen as with the least amount of impact to local tax dollars as possible. But it is, at the end of the day, it is critical public safety infrastructure for both law, fire, and EMS. And so we wanted, I think it was really important to be able to get this in front of you and let you know that we're working on it, we're actively working it, but this is a big train coming down the tracks, and we didn't want to have it catch you any more off guard than even this presentation probably does a little bit.
I just want to take this moment too to ask for any available ARPA funds to be allocated for this microwave project or radio upgrade system. It is a huge ask. Everybody is asking for any funds that we can possibly gather. And one thing that we have available to us is any of the remaining ARPA funds.
So along those lines, Liz, not to interrupt you, but we haven't got a commitment for the other 4, and we all got to be on this on the same page and be willing to do it. I'm all for the ARPA funds going towards this, but we need the other 4 players to be on board too. We got to move before the 31st of March, or we're going to lose that $2 million grant, right?
Yes, we have to move rapidly, and I know BCES is working on the agreements, or legal's working on the agreements. I would like to say that it's, hopefully we'll have something to you before the end of this month. That would be my hope. I don't know if Tom knows any more about those details or not.
The other players, are they?
The one thing that I can share with you is we presented a slightly abbreviated version to the Benton County Emergency Services Board, and got unanimous support and approval on the vote to move forward with the project to the 800 system and to start working the project more aggressively. So I think obviously that will have to be formalized in an interlocal and get the five players fully committed.
Yes.
But based on the board action and the conversation we had there, it seems to me that that's going to be it's a given at this point. I would be shocked if there wasn't support.
Are you presenting to the other three here soon?
I made an offer to present to the Benton County Commissioners. I have not heard back from them yet, and we'll be meeting with the rural Franklin Fire Chiefs next week. So starting to really make the rounds with the stakeholders to get the word out. Yes. I will also be, and Mr. Gonzalez will be on that distribution list, but I'll be sending out a monthly project update, written memo or statement that can probably be forwarded to the board as well, or the commission as well, if you're interested in that.
So, Mr. Gonzalez, what do we got left in the ARPA funds?
Commissioner, roughly $600,000. So Liz came to me with this ask, and the next addendum item also came to me with this ask. And there is a sense of urgency. That's why I wanted to bring it to the board as soon as we possibly could. So, and as you can see, the costs are really astronomical in all phases, and so.
Is there any funds that we can pull the other $306,000 out of to meet our?
And here's the thing that we've learned, in terms of, Curtis was coming up next for the ask for his building. The building funds that we have, that building fund that has about $400,000 from the sale of the property that we owned. So we could use that for any potential upgrades for his facility and his side, and the ask for the apparatus for the deceased individuals. So it's something we'd have to decide, and ultimately the commission has to decide where the sense of urgency is in terms of the use of ARPA funds.
But my question is, where are we going to come up with the other $306,000 to meet our 906?
Go ahead, Liz.
Excuse me. In the Emergency Communications Fund, the 13902, we do have an upgrade line in that, and I believe it's got maybe 4 million. No, not 4 million.
Oh.
Sorry about
I
that.
was going to say,
I was like,
whoa, I think we just, there's our
wow,
answer.
where did I get that 4 million? No, not 4 million. 400.
Curtis, I think we know who you need to talk to.
It's a good thing I'm not in the county.
Way to give us hope and then yank it right away.
So I have a little, in the 13902 fund, there is some money, but not, a lot of money.
Right.
So with ARPA and maybe with the upgrade fund that we have in the 13902 funds, we could at least get that first million taken care of. And then, like the chief was saying, all the entities, agencies are asking, legislations are asking for funding for this. And I think as a group, between all the agencies working towards this goal, we're going to get funding, and that price is going to go down. But that's just my 2 cents.
And one thing Mr. Brown, I'm sorry, but the surrounding area, all those, can't they be players in this too and reduce our price even more?
Okay, so we started out with a different direction. We were just going to upgrade the equipment that we had. At that time, that was in 2016, and Walla Walla was also ready for an upgrade. They're in a rough boat as well. So we shared with them our plan. They said, hey, it's a great plan, and they went ahead and upgraded. They're not ready to upgrade again. Oregon just upgraded, like you said, 2-3 years ago, and to this 450 system. Again, these systems tied together, but they're not in a boat where they're going to share in the 800 system. Klickitat County is solidly in the VHF system. I haven't spoke to them in a while, so I don't know where they are in their upgrade path, but I don't believe they're long in the tooth for the equipment that they have.
Tell them we got equipment for sale.
It's on eBay.
That's right. That's right.
On eBay.
I think theirs is a little newer than ours. A lot newer than ours.
So could I have some clarification? So we're talking about 3 projects. We're talking about the microwave, we're talking about radios, and we're talking about radio infrastructure. So the ARPA funds request would be specifically for the microwave system?
Wherever it's best.
Yes, wherever that money would whatever it would cover, but I think our first need is to upgrade the microwave system. That is step one.
And so,
And then step two is the radio infrastructure and subscriber units. 600,000 isn't going to stretch all of that, but
that's why I was kind of wondering. And so
Microwave.
then the one that's closest ready to go is the microwave system upgrade.
Yes.
And that project would break ground when?
As soon as the ILA is signed.
And so we have the plan, we have the contractor in place, all of this stuff is ready to go. We just don't have the funds to move forward with the project.
Everyone except for Franklin County has committed the funds, as I showed in that, the roughly the $1 million per agency.
Okay,
So-
and that project, our portion of that, if I remember right, you said that would be due sometime in 2025.
Correct.
that is correct.
Thank you.
What do you need from us today, a commitment?
Just need to let you know and ILA.
Yeah, I think the impending ILA is pretty critical mass, and then certainly if you can just give direction to Mr. Gonzalez. He sits on the executive board for Benton County Emergency Services, and that board is who's kind of steering my direction as the project manager on getting us down this path together. So certainly want to be accountable to the county commissioners and the city councils and all the elected officials in the process. But in terms of the tactical implementation, the BCS board is who's sort of directing the work here.
So one more time, I'm sorry. So the microwave upgrade is all Franklin County's responsibility, or it's the 12 jurisdictions inside of Franklin County's jurisdiction?
The current description of how that's going to be funded in the end is the same as the microwave. So the infrastructure piece of that.
I'm sorry, I was talking about the microwave. So this.
Oh, the microwave?
Yeah, so the microwave $1 million that we need
That would be Franklin County
alone.
alone.
Not the city of Pasco and Fire District 1, 2, 3, 4.
City of Pasco also has $1 million. They're one of the five. They're the infrastructure owners. The way that the board kind of looks at this is that there's five entities that are the owners of the stuff, that being Franklin County, City of Pasco, and then the other two cities and county. So if things were to blow up, Connell's not walking away with anything. It's really going to be Franklin County that has the communication infrastructure and City of Pasco that has the communication.
So it would be our job to own this and provide the services of its use to Fire District 1, 2, 3, 4, 5, that kind of thing.
Correct. And then that's all kind of managed by CCOM or BCS.
Thank you. And I don't even know who this question would be for, but is there funds that are allocated to those different fire districts, the hospital district, and all the different, roughly a dozen users of the system? Is there any funds that they have that could potentially help go towards this $1 million?
I don't know that there's, they're subject to the same kind of taxing limitations that all of us are. The thing that we can leverage are grant programs through, example, FEMA. There's an Assistance to Firefighters grant that we're putting in for right now for the urban area on an initial ask, and if we're successful, then we'll ask for the rural areas in the 25 program. So the fire districts and the fire departments have the ability to leverage some of those federal dollars a little differently. Same with law enforcement. They have access to Homeland Security grant funding that we do not. So those are some of the rocks I was talking about. We're going to try and turn over every single one of those and figure out how to leverage every single stakeholder's role in this.
So our ask could come from potentially up to a dozen stakeholders in the system that we are trying to
Absolutely.
Improve the infrastructure. So we could potentially have a dozen signatories towards Franklin County's upgrade,
Absolutely, yeah.
simply speaking.
Yeah.
Thank you.
But in that, we would also be going to them for their radios. If they want to upgrade the radios, we could be going to them and saying, hey, if you guys want these new radios, you're going to have to put into the kitty.
If we move down this path, they won't have a choice.
Exactly.
So that's one of the problems with all of our rural fire agencies, especially. They don't have a choice. Even the city of Connell. If we move to 800, they're moving. They're just locked in because they are subscribers to us. So we have to be careful that we don't overrun them.
Yeah, they're going to be obligated to.
Yeah.
It's just a huge cost. That's the $9 million that, for Franklin County side,
Yep.
in subscriber units, if that comes to fruition for that full price.
Happy to answer any other questions. If not, there will definitely be more information to follow. I'll work hard to keep all stakeholders informed as we go along, and I'm happy to come back at any point if the commissioners would like to hear more detail. So,
All right, thank you for your time.
thank you.
Appreciate it.
Appreciate your time today.
Thank you, gentlemen. And Chair, permission to speak. I was gonna recommend the amendment of this agenda and ask Jeff if it was okay and what the procedure would be. I'm assuming that that someone would have to make a motion. Because because we've ran, so the first item ran a lot longer than we anticipated, and I just want you guys to be able to focus, because I think we can move the coroners to next Wednesday and table the lease agreement till next Wednesday. I don't think there's a sense of urgency, but I do want to get to the .09 fund discussion because we have Councilwoman Blaisdell here. We also have Larry Leisure here, and it's an item I would really like to discuss because we have some RFPs that we'd like to get out. So, and then I did want to I know we want to talk about the creation of that Franklin County Code Revision Committee. So, with your permission, Chair, if we can amend that agenda so we can focus on those items.
Yes, you have my permission. Just want to say thank you to Curtis. It's been a long day for you.
I know. Forgive me, Kurt.
Right. No, it's.
But we'll get you back on the agenda. Thank you.
Whatever else I need to do. So.
Well, thank you. I know we need to make a plan for your situation, most definitely. So, thank you for your time. I apologize.
Mr. Chair, I move that we amend the agenda to remove items number 3 and 4 off of the regular business and move them to a later date.
I second.
I have a motion and a second. All in favor, say aye.
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 Any further discussion? No, I'm sorry. All in favor, say aye.
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 Motion passes. Thank you.
Thank you, Chair. Appreciate that. And thank you, Councilwoman. And if you wouldn't mind stepping up to the mic, and Larry, if you guys wouldn't mind stepping up so we can hear you.
Mr.
And
Gonzalez, I think next is the Commissioner Administrative Updates.
oh, okay. Forgive me for that. Forgive me for that.
Unless we want to amend the agenda and move that to down the agenda.
I would say it's up to you guys. The only thing I wanted to just kind of follow up for my update was going to be a little bit of the follow-up of the Consor study and
well, I move to move the Commissioner Administrator updates past the presentation for the creation of a county code review committee.
Second.
All in favor, say aye.
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 Thank you. Motion
There we go.
passes.
Now we can do it.
all right, thank you guys. Thank you. And Councilwoman, thank you for being here. Appreciate you being patient. And Larry Leisure, thank you so much for being patient. And Chair, this item comes before us, the discussion of the .09 funds. Like I mentioned, we have Councilwoman Melissa Blaisdell here, so thank you so much. And Larry Leisure from HWL, our management company. Just to tee it up a little bit, I've been in contact with the .09 committee that consists of the City of Pasco, Port of Pasco, and Connell. And they've been unanimous in their support of us using .09 funds for the use of upgrading the HAPO Center. The reason I wanted to have this discussion was to make sure that everybody's in consensus on the use of it, because we've heard Larry's presentation on his visioning project, and there's multiple opportunities that we could use the .09 funds for. And I had an opportunity to talk with Tim Anderson, our Chief Financial Officer. So right now, there is $7.3 million in that fund, but $1 million is allocated for the Port of Pasco for the sanitary sewer project for Dairygold. Another $17,554 is to support TriDeck. So we roughly have $6.3 million available. We do have to keep $350,000 in safeguard as an amount of cash in there that needs to stay in that account at all times. But we can also use an additional $1 million for emergent projects that could be used, like ICE and things of that nature. So there's quite a bit of funding in there right now. close to 6 million that we could possibly use to upgrade the center. We've talked about HVAC, we've talked about upgrading the ice, we've talked about the parking lot. So I think this is an amazing opportunity to upgrade that. One reason I wanted to invite the councilwoman is we've used a tremendous amount of ARPA funding over the years, and I think we can all agree it's been a bit of a sore spot that City of Pasco didn't utilize some of their ARPA funding to be, upgrade some of the center. So I just wanted to get all this on the table. I know that was a long way to get here, but I just wanted to lay it out for the public, all the facts of sort of how we got here, and just, the great opportunity to upgrade this center, and with Larry here and with his vision, I'm really excited about the future. So, and I'll open it up for questions from the commissioners to both of these esteemed individuals, and sort of it's sort of an open forum of where we want to go with these funds.
Well, let me make a comment real quick. So
Sure.
from what I understand, what was submitted to the committee was that Franklin County was approved for $5 million. The project was specifically for the HVAC improvement project, and that was the only thing that was submitted. So anything else, from what I understand, the money cannot be used for. It has to be for the HVAC improvement plan.
See, that's something, and Jeff, I don't know if you could speak to that at all, if there's flexibility. When you submit this application to the .09 group, so this emergent project element is something that Tim Anderson brought to the forefront yesterday. So
I'm not familiar with the emergent project, or if that's part of the grant, or, because if you look at the .09 funds, it's just two basic requirements, that it's for an economic development purpose, which this certainly would be, it's part of the HAPO Center, and then that it's part of a capital facilities plan.
Right.
Or economic development plan, which probably would fit within the latter. Certainly the facility itself would. So I'm not sure about
yeah.
that. Maybe you could send me what Tim.
Okay, yeah, I'll send it to you, and to the councilwoman's point, I guess what I'm thinking is, if, let's say the committee designated us 5 million, the money is still in that bucket, and if we were able to use the emergent projects, it's not as if that group codifies us to that specific amount.
Forgive me, because I'm really new at this, so
Yeah.
I don't know specifics, but I'm going to just read exactly what it states in here. It says this project will address the lack of HVAC in the arena portion of the HAPO Center. This will facilitate a year-round increase of the facility's use in the arena portion. As a result, the HAPO Center will successfully attract more special events, sporting events, and specialty trade shows. This will result in direct increase in tourism-oriented revenues and support Pasco's retail, commercial, and hospitality businesses. They also approved TriDeck funding. They requested $25,000, and it's specific to what they were asking for. And then there was, it looks like 4 of the City of Pasco projects. It looks like the City of Connell, the City of Pasco, and the Port of Pasco were recommended for bonding.
And that's something that's been an ongoing discussion for the bonding, which I'm not going to speak for the commissioners on how those individual meetings have gone. I know Randy and Stephen have been talking to our commissioners individually, but publicly we didn't want to go to the bonding element, so we left it at that in a public meeting, and then they came back to us and seemed to be lobbying. I don't know what, I don't want to speak for you guys because I don't know what they're talking to you guys about. So, in terms of the bond element, I'm assuming that's what they're talking to you guys about, right?
Well, the discussion I had was that they were going to look for their own source of bonding.
Okay, yeah.
And that's where it was left. And I think that that's where they're going to go, as long as they can get the funds to bond with. We will not be on the hook for the
right
for the bonding issue.
Right, and we've been pretty transparent about that.
Yes.
From the get-go, that we
That
weren't.
was my meeting discussion.
Right, yeah, so, and, like I mentioned, we've been pretty transparent about our lack of desire to support the bond, with the .09 fund, so we're not tied to that debt service, so.
The only reason why I brought that up is because the committee did make the recommendation for the rest of them to be recommended for bonding except the Trideck and Happel Center.
So my question would be, so in your understanding, if we wanted to alter if we wanted to alter the use of those funds for the Happel Center, we would need to go back to the committee
And resubmit.
and resubmit
The request.
a different request.
Mhm.
And so,
And just so you know, they meet, I believe, they met 4 times in 2023. So, and upgrading an HVAC unit in the arena it's definitely not a bad thing. I mean, that arena should have had air conditioning a long time ago.
It doesn't have any air conditioning.
I know when you're having an event in 105-degree weather, rolling up the door isn't going to do a whole lot. So, I mean, it's definitely a needed.
is your understanding that we have a yes or no before us, and a yes would approve the whole slate as presented, or we can pick and choose? What, do you have an opinion on that, anybody?
And Councilwoman, respectfully, and my understanding, Commissioner, is in a conversation I had with Stephen over at the port, he said, we're good to go. I mean, we don't need to go back to the committee. There's no quid pro quo in terms of us being able to use these dollars and then keep putting us on the hook for a bond. And unless I misunderstood what he said, that's not my understanding.
That's what I was told this morning from Steve. So
So this is a yes or no,
this
not
is
a
for
pick
the
and choose
HVAC on
system
the
alone.
arena side, $5 million.
So action today, if we were to say yes to that, it would not commit us to any of the remaining projects. That could be addressed at a later date in a separate action?
As far as I know, this is all we're talking about today.
Yeah, so and perhaps I misunderstood, but I know what he told me. He told me, yeah, go ahead and use them. We don't need to bond. And if I misunderstood him, forgive me, but I'm,
It states it in this, and
Yeah.
you were, actually, it was sent to you January 10th, 2024. It's the Port of Pasco memorandum for.
Right, and I talked to him much, yeah, that's.
So if I may.
Yeah, okay.
Maybe we pursue, and I think Mr. Leisure has got RFPs out for the
Yeah.
HVAC. We pursue this, but we clarify, and if we have to, we amend, and we.
Absolutely.
We use it for the parking lot. We use it for the other items that we need to upgrade. The ice.
So I believe you have, from what was told to me this morning, that
Right.
it has to be resubmitted if you use it for something else.
Okay.
Press would verify, we'll
Yeah,
just
we'll,
verify, and if it is,
we'll
resubmit.
Yeah, I know, and that's why I invited Stephen. He had to go to another meeting because things ran long. But yeah, well, let's do that. We'll figure out what the next steps are. You're in the process of investigating what it would cost anyway, and you thought
Yes.
that we could get a pretty good deal based on your expertise for an HVAC system anyway. So we're in that exploratory phase. So it's not.
So a question here on this. So today, we would need a consensus that the direction we would head towards is the HVAC system and potentially what Mr. Leisure is going to present to us. And if during this process we needed clarification, we're not taking a vote that's a hard response
Right,
today.
exactly. I think the good thing about today is at least we can consider, what's our priorities in the HAPO Center. Because if with Larry Leisure's expertise, I'm really confident we can maximize whatever dollars we get. So I didn't want to just go, hey, let's get HVAC. Yeah,
We're headed
You know
where I
okay.
understood we were. Thank you.
Gotcha.
Well, Commissioners, a very enlightening meeting this morning. You've you've got some very large numbers to be talking about and as to what you're doing. But I would also share with you, and I appreciate just a few minutes, and I'll be very brief. The last 4 months, we have been looking at very carefully the next steps for really what needs to happen out at the project. Economic development, no question, it's very, very important. But there are other issues there too with your facility and where it is, and we'll be talking more about that as we go forward. Number one, we are recommending, certainly as a body to recommend to Mike and to yourselves, 3 areas that we think are really critical that can happen. And with the $6 million number to talk about at this point, our number one is definitely you've got to deal with the HVAC in the system statewide. I won't go through any of that. That's something that's very important. It's also economic development as something that would be done, and so we're very supportive of that. We certainly think that there are a number of ways to be looking at this to get something done in that facility, and we are putting together an RFP that will be done shortly for your approval, review, and so forth with Mike over the next few weeks. It's in the process. We're talking with a number of contractors, and any suggestions that you may have of strong HVAC contractors that understand the process in the state, we'd love to talk with. We've talked with a number already. We have some numbers that are substantially different than what has been talked about, 5 and 6 million. It certainly should not be that number, in my view, but we haven't gotten there yet. I mean, there are working drawings from the other group that were done. Many others don't even want to use those working drawings for the arena. So all of that is moving aggressively. Mike has been very helpful in saying, let's get this number one. It's number one on our list. Number two, though, on our list, which I think is extremely important, and we should have by the end of this month, a letter of intent from the youth hockey organization as to a potential plan there to look at putting some funding in the pavilion building and needs. And when you talk about economic development, there's probably even more of a reason to be taking care of that facility because of what that does bring into the community when they do have events and they can do that. So that's our number two, assuming funding is available. We haven't gone to an RFP on that, but there will be a letter of intent. They are presently leasing the facility, as you know, and so we've had some really good discussions with them to take the next step. The third area, which in my view today is down a ways, we do need to work parking lots, dealing with the parking. Striping and those sorts of things are not significant, meaning price-wise and so forth, but it does need some serious work. Nothing's been done there for quite a long time. I'm talking about pave overlay and so forth. That would be our third request, and that all of this would come back to you with an RFP right away, meaning for all of those elements over the next 30 days. Our intent is to move quickly, but we're doing a lot of research presently. The council has also suggested that there needs to be some public notices before the RFPs, and Mike is working on that, and we're moving forward. But thanks very much. Appreciate your consideration in that regard.
Mr. Chairman?
Yes.
So I would hope, Mr. Leisure, if I could, we have a couple fine outfits here in the Tri-Cities, and we'd like to try and keep this local if we could. And I know your
Sure.
RFP reaches out further, but we have Campbell and Bruce that is well respected in our area, and also Apollo, and I think there's even more than that, but I would hope that they would receive these RFPs with an opportunity to put in a bid too.
Definitely. And we're talking with them now, so that we're
Fantastic.
we're not requesting their RFP or their costs or anything at this point, but I think it's important the sooner that they can get in to look
Yes.
at what we're talking about, that we'll be pleased. We'll bring to you the best numbers that we can that
Excellent.
make sense.
And if on the youth hockey, I know that they were going to step away and let us get to work on that. And the last time you and I talked, you were talking about having some money available to start the process in that arena to get it up to snuff with the
Yes.
ice and everything. And Mike, I questioned you the other day about what kind of money we had in our HAPO fund, and I think we're almost to the amount that Mr. Leisure was asking for. Is, I mean, they would submit, you know, the payment process of what to be used for. They could use those funds in that HAPO fund, right?
The funds in that HAPO fund are really flexible, and Jeff and I talked about it yesterday, some of the uses. I mean, obviously, we'd have to vet it to make sure, but the uses are pretty broad.
Until we get
Yeah.
clarification on the
Right.
0.09 funds.
Absolutely. So
Just
yeah.
so we can keep this process moving forward, and you
The only
can,
thing I would add about that is any use of the funds over $100,000, we want to notify the city and make sure that they're.
well, that's where I was going next, is, did we notify the city on our HVAC improvement that we did? Because we were, you know, we're in this together, we're actually helping out their hotel motel fund by putting heads in beds, and we had the understanding, and I know you're new to this, and I'm putting you on the spot.
I'm not new to the hotel industry because I've ran the hotel on 68 for 10 years. So I can tell you, and this is from personal experience, this is not my counsel hat. We do not depend on rooms from the HAPO Center. And and it's not just me, the Hampton across the street. You call her and she'll tell you the same thing. We've had to learn to go find business other places. Would I like to depend on that? Yeah, it'd make my life a lot easier. And it all depends on when, and again, this is the history of when the track was originally built to what it is now. A lot of factors have changed. Now we have a convention center with a attached hotel, which I've also worked at the convention center. So the dynamics of everything have shifted, and when they're bringing meeting planners in and they're doing large conventions, the HAPO Center isn't necessarily looked at as the first option. They're now looking at the convention center. So where originally they were looking at Red Lion Pasco. So the dynamics of everything has kind of changed over the years. And the 3 hotels surrounding the HAPO Center have, like my hotel specifically, we depend on construction. And majority of the business I go after is the long-term guests. The people that are here Monday, checking out Friday, and then the sports teams for the weekends. So,
when you say sports teams, are you talking about the youth hockey? Because they've got an event coming up with 54 teams coming in here.
So typically, like softball or hockey, all 3 of our hotels will fill up first, but hockey isn't, I haven't seen a lot of hockey teams. I know I do have some hockey coming up in March, but it all depends on what's going on in the area and where, if they have like a host hotel, and if it's directly around the event where they're holding. So,
To just clarify, on the softball teams, yeah, that's our property. We rent that to Pasco for $1 a year, and so all those teams are courtesy of Franklin County.
Right, but I know the city of Pasco's put a lot of money into those fields too
Well,
over
yeah,
the years.
Yeah, but I'm just saying, we rent that ground to them for $1 a year. I'm just trying to, if you didn't know, I'm just trying to
I do
inform
know.
you. Okay.
I do my research, especially around that area, just because it affects me in my day-to-day business. And now being on city council, it's kind of opened my eyes a little bit more to be more aware of what's going on. So yes, I was aware of that.
All right.
And thank you very much. Obviously, that's one of the major reasons we're requesting your consideration, taking the leadership of a master plan of the area for that very reason, because I think it is critical. And I do know that our experience is these sports teams bring a tremendous amount, especially on weekends, for the most part, to the economic development side and definitely to the hotels. But we will move forward, and we'll be back to you with our other areas here by the end of the month and the first week in March.
Thanks, Larry.
A couple of questions, if it's okay with the chair. So last time you were here, Mr. Leisure, we talked about 90 to 120 days to kind of put together a master plan. Have we begun that process?
We've not moved it to the next step until I bring you a proposal specifically.
Okay.
But the answer is yes, it is in the works. As a matter of fact, I've got one critical meeting in about 4 minutes, and this is critical. Don't get me wrong. This is very critical, but it has started. But we're coming back to you with 2 or 3 options. So it is in the works. We recommended, as you had indicated, that the commissioners would be inviting the city of Pasco to participate in the master planning of the whole area, including the private lands, including her hotel, because they do need to be considered, the private real estate as well as public. And as we've talked about, seeing other uses in and around here that really will help everyone involved. Do we need 5 new hotels around? I don't think so. That's not the intent.
Not yet.
But we certainly see this as our next step. And yes, we are definitely moving forward.
Thank you. I appreciate your list of 1, 2, and 3 in the needs there. I agree with you. We're on the same page. Whenever I heard the numbers of $5 and $6 million to put some air conditioning into that arena, I was amazed at those numbers and look forward to seeing the prices as they come forward. Something that's been near to my heart as a contractor for a long time is maintaining the facility and maintaining that parking lot. So I really look forward to seeing stripes in that parking lot and an upgraded and cleaned up facility. So look forward to working with you and conversing about some of the needs and the mutual interest that we have as the county and the city around that facility. So thank you.
Thank you for your time. Appreciate it.
Thanks very much.
To running.
Moving on.
Appreciate it.
Presentation creation of Franklin County Code Revision Committee.
And Chair, this is something that Commissioner Didier and I began talking about probably a month and a half ago or so. He's had an outcry in the community to look at some of our codes, and that's especially in our process. And I won't speak for Commissioner Didier because I know he's had community members that would like to get together, form this organic group of Franklin County citizens that are engaged and want to make our code system better. So on the surface, sounds like a good thing. So I'll toss it over to Commissioner Didier.
Yeah, this was something that we had talked about, and we handed it off to Commissioner Bauman, but I know that Commissioner Bauman, he's trying to get up to date on everything. He has taken on a lot of responsibility, and so I've offered to retake this over and to get it moving and to be on the open and transparent part of this. As soon as we do get our first meeting date, place, and time, it will be posted for anybody to attend. And so I'll be working on putting that together. I already started this morning, and I will be given that date, time, and place to Mr. Gonzalez to post on our website.
Absolutely, and I think that's a great idea.
Okay. And that's all we really need to talk about.
All right,
that.
thank you. Moving on for
May-
public comment. Is there anybody?
May I
for
make a
public-
comment about that last item just real quick? I agree. I've had a number of people reach out from the community. I've got some emails that I haven't even opened yet about that specific issue. And my only request would be is that we have that we not just say, go fix something, but that we put a parameters in of what we're trying to do. So that's all. Thank you.
All right, thank you. Moving on to public comment. Is there anybody in the room for public comment? Is there anybody on the phone? Hearing none, moving on.
We got to go back to
Back to commissioner updates. Mike Gonzalez.
Thank you, Chair. I'll try to be really brief because I know we've had a long day. But I had an opportunity to speak with Clark Worth on the Consor study follow-up, and I just wanted to let the commissioners know that he'll deliver the full report by March 1st. He's taking the recommendations into account, but that doesn't mean we can't get to work. So what he recommended right away to get to work was to form a budget task force, made up of elected officials and a commissioner to get to work. Some of the things that we can do right away is start creating some financial policies. That was one of the recommendations for things like HAPO Center and just various departments. We talked a little bit about what would get there the fastest, but certainly levy lid lift and selling the properties are not really priorities, and those are not preferred options for us. So, other things that we talked about yesterday, obviously the VEBA contributions, that's something that can have an impact on us if we're trying to save money. So that's going to be one of the recommendations. And I've already started talking with Wes Harris and Margot about, how do we get to a place that makes sense. The utility taxes, Jason's working hard to identify grants, the 911 sales tax. And then, Clark also suggested that, if all the preferred alternatives don't come to fruition, that we have to look at the catastrophic outcomes too. So that's something he recommended to start doing sooner than later. I'm looking at this bi-county court system, if any savings exist there or not. That just got started the other day. So I'll leave it at that. I've got a lot of hard work ahead, and we'll be beating the bushes to where we can find money to balance the budget in 2025. So that's all.
Commissioner Bauman.
I'll also be brief. I think you've received the minutes of the Bi-County Superior Court discussion about that potential split. Attended that meeting. Had a meeting with our county engineer, public works director, talked to him about some of the concerns and needs that we have and potential places that we can go for funding, grant funding. In relationship to that, I've talked with Mr. Valentine a number of times about how do we do that, and I also sat down with Patty Murray's office and discussed potential some federal funding to help us with the need that we have out there. And Mr. Valentine has also had a conversation with that office, and we're going to collaborate and figure out looking forward. Met with the Port of Pasco, as referenced earlier, about the .09 funds and the allocation of those. WASAC meeting in a virtual format. The conversation was primarily around public health needs and funding. Yesterday, had most of a day working on a drill with the Franklin County Emergency Management, and I want to say that Mr. Davis out there is doing a fantastic job. I am really, really impressed at how thorough and that went. And at the end of the day, there was a debrief with some of the oversight. There was some representation there from I believe federal oversight, and they kind of described what they seen as observing the drill that took place, and they were really impressed. That continued on through today, and that's in preparation for an actual drill that will be scored in March. And I would have a request of you two commissioners that I would love to be able to be the presiding commissioner in March, if that's of the will of the other two of you. I would appreciate that opportunity. And a lot of other meetings and calls in the meantime, but that's my report.
Thank you, Commissioner Didier.
I would just like to say yes. I'm I'm good with you being there in March for that. I think it's good. Me, Commissioner Mull and I have been through many of those, and very well done out there. As far as the Bi-County Superior Court, I have not seen the minutes of that meeting, and I asked that it be recorded. I take it was not recorded?
No, sir. There was several people who weren't comfortable having it recorded.
Was Benton County invited to the meeting?
No, they weren't. I did speak with Tiffany Rung, who's their court administrator. She said that they were not invited. I also heard from Jared, their county administrator, and he confirmed for me that he was not invited either. So what I told both of them is that the next time we have a meeting, I'll make sure that they get a calendar invite.
So the last question I have about the meeting was, the person that's been pushing this the hardest was the sheriff. Was he in attendance?
No, sir, he was not.
So if I may, I'd like to speak to a couple of those things. So as we sat down there, the people that were in attendance appeared to be the ones that were invited there. It was an expected number. The chairs were all filled with the exception of one that was set up. So it was as it was intended to be, it appeared. I expressed, and you will find once you have the opportunity to read those minutes, you'll find I had a real concern. I had a real concern that it was not going to be recorded. I had a real concern that the auditor's office was not in that meeting. The Superior Court had no representation there, and neither did Benton County. I asked that those observations that I made be clearly stated in the minutes of that meeting, and they were. You'll see that, and that's of grave concern to me. As you just stated, our sheriff has been the one that appears to be pushing this idea, and he has been vocal about saying that it's time for elected officials to stay out of the business of other elected officials, and I said that in that meeting that's something that he appears to be pushing is the Superior Court split from Benton County, and that I was concerned that it was something that appears to be being done in the absence of those that are the most impacted by those actions. I did say that I believe that the jurisdiction or the authority or the responsibility of taking the lead on that should be taken by this office, the Commissioner's office. If that conversation were to take place, I believe it should be led by our office. And so I would have a request of you two is that as we had a consensus that we've asked the county administrator to collect information on the bi-county funds that we expend, not just in that way, but in other ways. And so I would ask that our office and administration focus our energy on working on collecting that information. I would be happy to be a part of that. But to continue the conversation of the Superior Court split, I believe is inappropriate at this time in the way that it has currently been undertaken.
Thank you. So with that being said, I'd like to reiterate our letter of support for the Bi-County Superior Court. I think that that's something that we need to put together, put an olive branch out there that we're not looking to separate. We're just looking to analyze. And I think that needs to be said.
I can definitely start drafting something.
Please.
With
if
Chair,
the other
your
commissioners
permission.
in agreement.
I feel the same
Okay.
way. So
I'll put together a draft for your guys' review.
And the last thing I'd like to ask is that we revisit the February 22nd, what do you call that, Mr. Gonzalez? It's a
mission vision.
Yeah,
value vision workshop.
I've already seen several emails of people that aren't going to be able to attend. So if we don't have the whole courthouse involved in it, I don't think it's going to be of use, and it's a waste of taxpayers' funds. We need everybody involved.
I'm in agreement. We need to have the majority of the people there. If they can't attend, then I'd say we scrap it.
Yeah, I've gotten quite a bit of acceptance so far. So respectfully, if you guys wouldn't mind hanging on till next meeting, and then we'll evaluate and
Just
see.
want to make sure that there's plenty of people that
Absolutely.
are interested in going and participate.
And I'll leave you guys with this. I mean, ultimately, it's it's the three commissioners' mission, vision, value. And my intent is to have as many people in the courthouse participate, but ultimately it is your guiding vision. So, but I totally understand where you're coming from.
Well, we're in a very tight budget
Yeah.
situation too, and it is money. It's taxpayers' money, and we're looking at that presentation by Conor, and I'm pretty concerned about our future.
Absolutely. So let me gauge. I'll make calls
Okay.
and see what the feeling is and how many people can show up. But you got it.
I just want to share, I believe it's a valuable function. And I guess the way that I would see it is we don't shut the lights off trying to save money. There's functions that we need to do that are a necessary portion of, and one thing that I think that is in need right now is a direction, and I think that's kind of what it is to take the three of us and provide some direction and say this is the direction that we're going, and I recognize that there's a few that won't be able to be there, but it's primarily about the vision of this board, which is the vision of the county, and I think that portion of it is very valuable, and I recognize that there's a small cost to it, but I believe that it will provide some stability to staff and departments, understanding the direction that we're headed. Thank you.
All right, so moving on, last week I had long-term aging and care. Pasco will now have a direct office opening. Now, grand opening will be this spring, and they're busy working on succession planning, trying to get the younger employees being cross-trained for the retiring workforce that they have. Aging and Disability Resource Number is 509-412-1013. It's going to be located at 2715 St. Andrews Loop, Suite A, Pasco. And it's their intent to provide information and to help coordinate services for those in need and providing early services so the people can stay at home as long as possible before needing care. Greater Columbia Behavioral Health Meeting.
It took me
So that's a mouthful. Good numbers there. Medical Lake Mental Hospital has increased to 28 beds, but that is basically strictly for violent cases. Franklin County has 7 residents there now, according to the sheriff. Is a little concerning. I think it took away some of the beds they had for other mental health cases, but these cases are basically just strictly volatile felons.
Yeah.
So, and that is it. So moving on, do we have well, we already covered that. So executive session, I'm going to call for an executive session under RCW code .110, section 1, section I. And I ask that the 3 commissioners, county administrator, and legal be present. Thank you.
How long?
And I would say 5 minutes.
Thank you, Chair.
4230, 110I.
42, 1.
Is that the right one, Jeff?
Yes,
Okay.
potential litigation.
Yep.
I know it's been a marathon. It's been a marathon meeting.
No kidding.
He's already
Longest
gone.
one I've been in so far.
Yeah. I had a Benton City meeting that went till.
So we've come out of executive session. We're going to extend for another 5 minutes.
Okay, we're out. Sir.
We've come out of executive session. We're going to extend for another 5 minutes.
No, Chair, we are done with this day.